Morning. It's November 17, 2025. Welcome to the Appeals Court. My name is Vicki Henry. I'm your panel chief today, and I'm delighted to be joined on my right by Justice Sachs and on my left by Justice Tan. My pronouns are she, her, and judge. You're welcome to share your pronouns or not share your pronouns as you see fit. We have 15 minutes per side here in the Appeals Court, and for better or for worse, we do not have rebuttal. I can assure you that we've read your materials. If you're here for cases 2 through 6, I think you're welcome to listen. You might want to brush up on your record because we often ask questions about the record, and we often know the record better than you all. So I'd encourage you to be prepared for that. And I know we do have a lot of questions today. I hope you take that in the spirit that we have prepared for argument and we're interested in your case, and we would like you to help us decide your case. With that, I'll call the first case, 2025 P160, Commonwealth of Massachusetts versus $85,200 and other assets. And I will say, you see that we all have an iPad up here, and that's because we try to be paperless here, or very little paper. And we have your materials on there, so that's what we're looking at if we're looking away from you. We'll hear from Attorney Thompson first.
Thank you. May it please the court. Matt Thompson for the appellants, interveners Robert and Andrea Petrino. This is an appeal from a money laundering forfeiture case. That's 267A, Section 4, in which the trial court, after summary judgment, ordered forfeiture of the $495,320 as well as a 2015 Jeep Cherokee. The legal question here is whether or not the Commonwealth presented sufficient evidence to believe that there was probable cause that the defendants in rem were involved in a money laundering transaction, and then what money was obtained directly from that transaction. So in essence, under the probable cause standard, you're asking, did the Commonwealth present sufficient evidence to indict each of the defendants in rem?
So I want to make sure I understand. So your argument is basically the Commonwealth did not meet its burden of proof, and particularly at least as to assets over $106,500, so the burden of proof never shifted to your clients.
That's correct. I would say they didn't even reach probable cause on the $106,000. My argument is that $106,000, because that was all that was alleged that was stolen and unrecovered, is the cap on what can be forfeited. And that was what was pled in the petition. And that's the evidence that they presented. They didn't present any other evidence as to believe why anything above that could even be possibly involved in a money laundering transaction. And
in the summary judgment papers, neither party that I could see focused on whether the Commonwealth was proceeding on a theory of money laundering under 267A, Section 2, Subpart 2, or Section 2, Subpart 3. Your brief on appeal focuses on Subpart 2. The Commonwealth focuses on Subpart 3. The judge didn't say that I could see. So which is it? And what's your response to the Commonwealth's Subpart 3 argument?
well, my response is that that the Commonwealth proceeded in the first instance in indictment in the criminal court under simply a concealment money laundering theory. They didn't proceed. They didn't indict under a structuring or a transportation and possession theory. So it was a concealment money laundering indictment. And so that's what I believe that they proceeded on here.
They don't need to have even indicted, let alone convicted, your clients to obtain a civil forfeiture, correct?
That's correct. That is correct. Of course, I think they would prefer to have a conviction because it makes their job easier, but they could proceed otherwise. But really, down in the trial court, there was never sort of this presentation of evidence or even a case made as to why the defendant properties were obtained directly from a money laundering transaction. They sort of went on a theory of, look, Robert Petrino has a long criminal history. Therefore, every worldly possession of his is forfeitable. And that is what, I think that's a fair and reasonable assessment of their approach, considering what they seized from these searches. Every single dollar in every single bank account, every single dollar in every single safe deposit box, every piece of jewelry of any value from his home, cash from his home, didn't matter in what denominations or what bulks, if it was of any value, they took it. And so that's just sort of.
Your client presented some testimony about wages earned during this period in the immediate, 6 or 7 years prior to this case. Did you take a position about what percentage of that was savings from the job or jobs?
I didn't take a position. He earned the gross income was $450,000 over a 3.5-year period leading up to this, so 2014 through March of 2018.
Well, that's part of why I asked, because around here that, $150,000 a year might not let you save, but I didn't know if you took a position on that.
No, I mean, my position was in the first instance, it's the Commonwealth's burden to show probable cause as to why they can even attempt to take more than $106,000, and then break it down from there, because now you have to show, okay, there's $106,000 in stolen jewelry. Well, okay, now what proceeds came out of that $106,000? Because this isn't a larceny forfeiture statute. It's not, well, he stole $106,000, therefore we get $106,000. This is a money laundering forfeiture statute.
Right, but they argue the federal courts have disclaimed the requirement to trace money to a particular underlying illegal transaction, and given the low burden of proof on the Commonwealth, we should follow suit.
Well, the federal statute, I would argue, and I think, it's pretty clear that the federal statute is much broader in its reach than the Massachusetts statute. They use words like traceable and involved in. So, for example, involved in would mean if you took money and put it, arguably, and there's a lot of case law in federal court that rejects this, that if you took money and put it into this big sort of pot of clean money, dirty money into clean money, then the clean money becomes involved in, or something like that. But courts have mostly rejected that theory too, or traceable too, where you could trace money where it's maybe not the last transaction, but you can trace it back, and there was a money laundering transaction here, but the last transaction was not a money laundering transaction, it was a money spending transaction, which of course is not punishable.
So can you talk to me about why can't we analogize? So here, the SJC, there was some discussion about 94C, Section 47, right, which is the forfeiture statute that we have here. And,
yes.
And the SJC discussed in Commonwealth versus Brown that there's language in 47, right, that says proceeds traceable to an exchange, right? And in that case, the SJC said, well, it doesn't have to be that you have to show directly, right? That and that's where they articulated that under 47, the Commonwealth could show that assets were probably derived from illegal drug transactions.
So that is a standard for the drug forfeiture
That's right,
statute.
but it uses that language, right?
Correct, it does.
So-
It does, and I think the drug forfeiture statute is much broader and reaches more property much more easily than the narrowly drawn money laundering forfeiture statute. And they don't use words like traceable to or facilitated or involved in or anything like that. That's intentional, I would argue. Intentional because the legislature, for example, copied almost verbatim the federal money laundering forfeiture statute, and they had, of course, at their disposal the federal money laundering forfeiture, money laundering statute, and they had at their disposal the federal money laundering forfeiture statute. So if they had wanted to make this broad statute where they could reach that type of property, they had the means to do it. They had a template to follow, and they decided not to. So they carved out that broad language in Section 47 when they by cross-reference said in the money laundering forfeiture statute, you're going to follow the procedures in sections B through, but they don't say anything about A, which is the scope of what property you can you can grab. They narrowly drew it to obtain directly as a result of, and I think that requires a direct nexus, and I think it's a lot more narrow, and it's intentional, in my opinion. I don't know any other way to read it. It's not an ambiguous statute as I read it.
Is it possible to identify money or property that was obtained directly as a result of a money laundering transaction without identifying the money laundering transaction itself?
I don't see how you can, because by the words itself, it requires you to find what money laundering transaction produced money. So I always say, if you threw $100,000 into a washing machine, that's the money laundering, and it spit out $75,000, that would be money obtained. $75,000 would be money obtained directly as a result of money laundering. It wouldn't be the $25,000 that would, you would say would be fees or whatever. It's what spit out the backside of the money laundering transaction. And that analysis hasn't been undertaken, in the trial court. And of course, this is, as far as I know, the first time this statute's been reviewed by an appellate court in Massachusetts. But to me, it is a very straightforward statute. And, whether that frustrates law enforcement or the Commonwealth, that's, the legislature spoke. And I think, they wanted to limit the reach.
So you're looking for a remand?
I don't think they produced, I don't think they produced all of their best evidence, in the trial court, and they didn't satisfy their probable cause burden.
Well, they moved for summary judgment.
Yeah,
Did you cross-move?
I did.
Okay.
And so you talked about a cap, right? That you feel like it should be capped at the value of the jewelry that was stolen that was at issue here. However, doesn't the government in their pleadings, in their petition, they do reference his history, right? And discuss directly the affidavit, they call it the Murphy affidavit, which outlines your client's long history across states of his previous
Yeah.
activity, right?
Yep.
So what?
But if you look at the affidavit, a lot of it does reference, where property was returned, recovered, et cetera, et cetera. So they didn't take the steps to sort of show that this was unrecovered. It must have been, and when was the transaction? They have stuff back there into, 2008. And, at some point it becomes too attenuated to even, and this, I think, is the purpose of the sort of limiting scope of the money laundering forfeiture statute. You can't, I'm pretty sure that the legislature's intent was to foreclose as sort of, let's go after every person ever convicted of a criminal offense and take everything they have because, and make them prove that whatever they've obtained or whatever they have in their possession now wasn't from criminal activity 10, 15, 20 years ago. There has to be a limit on that. And I think the way this statute is drafted does limit that.
So just taking a very simple situation. So let's say somebody has $100,000 in the bank. They have no criminal record, but then they steal some jewel and they convert it to cash and they buy a house, right? And the Commonwealth comes and says, you've committed money laundering, and the person pleads guilty. And I take it your position would be the $100,000 is completely free from being touched because there's no evidence it was from criminal activity, right?
That's right.
Okay.
That's right. And that's the case that mentions a drop of ink in water.
So then, but let's say somebody has a long criminal history then, but they have $100,000 in the bank and they steal a $50,000 ring and they convert that into cash and they use it to buy a house. Your position is the Commonwealth would still be limited to recovering only the up to $50,000 and they can't get the other assets.
That's right. That's right.
Did your summary judgment motion show or try to show that the Commonwealth could not identify these proceeds as obtained directly as a result of a violation of the money laundering statute?
It did. It did. I walked through each step because I think it's important. You have to walk through the step, okay, what was stolen, what was alleged stolen. from those stolen goods, what proceeds came out of them. Because only proceeds can be used in illegal proceeds can be used in a money laundering transaction. So then use those proceeds in a money laundering transaction. What's the transaction? And then what was spit out of the backside of that? And that's money obtained directly as a result of a money laundering violation.
So your point was not that there wasn't a dispute. Your point was not that there was a dispute of material fact over whether certain of these properties were obtained directly as a result of money laundering. You said your theory was that.
I'm saying they didn't get past the first step. They didn't even show what proceeds came out of the $106,000 of stolen jewelry. So, you know, I mean, just in theory, that's fenced.
Didn't on their summary judgment motion or couldn't?
Didn't and couldn't. I've not seen any evidence that would lead me to believe they could ever satisfy that burden. They do have to show proceeds. It can't be just he stole $106,000, therefore we get substitute assets, which is a federal statute provision that allows for that. You know, we know he stole $106,000. We can't trace it because of his conduct. Therefore, we get to seek substitute assets in equal value, and that's not part of our Massachusetts statute. Again, intentional, I believe.
The judge stated in her findings, right, that she really had some issues with your client's sort of claims of legitimate source of the money that was seized, right? And there, I think the Commonwealth included in their petition this table or chart of discrepancies and inconsistencies between the deposition testimony and other statements that he'd made. Can you comment on that?
Yeah. First of all, doubts about believing Mr. Petrino, I don't think are sufficient evidence. Where that money came from whether you wonder where it came from, and that's what we're doing, we're speculating, wondering where it came from. It doesn't mean that it came from illegal activity or, more importantly, what was alleged in the petition, larceny. So let's just say, I'm just throwing out an example, let's say it was from gambling proceeds, and he didn't want to declare, you know, taxes or something. And again, I'm just throwing out examples here. Then that wouldn't fall under the money laundering transaction as pled in that petition. And you know, this
would
goes
or
again
would
to,
not?
I'm sorry, would not?
Thank you.
Because, did I say would?
I don't know what you said. I just
okay.
couldn't hear, and it seemed like a very important point.
Yes, yes. So, you know, it goes back to why it's so important that the Commonwealth at least attempt to prove proceeds, money laundering transaction, and then what came out of that money laundering transaction. I think it's very straightforward. It's an exercise, maybe one the Commonwealth didn't want to take because it is difficult, I assume, I can recognize, but that's the way the statute was drafted.
All right, your time is up, so I'm going to ask you a question and see if my colleagues have questions. But it's very helpful to us to right-size the case and understand exactly what we need to decide and what we don't need to decide. So I take it if we don't agree with you, if we think the Commonwealth did meet its burden of proof, you didn't make an argument that your client met its burden of proof as a matter of law, right?
I did not.
Okay.
No.
All right, thank you very much. We'll hear
Thank you.
from the Commonwealth and Attorney Padalano.
Good morning, Your Honors. Assistant District Attorney Matthew Padalano on behalf of the Commonwealth. Your Honors, this case boils down to what the Commonwealth's burden is in a money laundering forfeiture case. If you were to believe the defendant, the Commonwealth, or the interveners, excuse me, you would have to tie every single dollar seized to a specific money laundering transaction. The drug forfeiture statute has much case law, and unfortunately the money laundering forfeiture statute does not in this area. And so I think we are forced to draw parallels from that case law.
I take it you agree with your learned colleague that it might be helpful if we published a decision on this?
I think it would be. I think that the standard is parallel in all aspects to the 2004 Audi sedan auto case, where they describe that the standard is that you probably derived from illegal drug transactions, and in this context it would be illegal money laundering transactions.
Oh, but he says the statutory language is really different.
So I believe that there's a pretty straightforward answer for why they're different. Drug transactions tend to be for profit. They tend to be, I will give you drugs so that you give me money, and a business is established in that way, whereas money laundering is more often for the purpose of concealment, and so you're not necessarily gaining money or gaining proceeds from those money laundering transactions. So for example, you could change money stolen from a bank for gold bars for the exact amount, or may even lose money in that washing machine as it's described. And I think the obtained directly language is most likely to prevent innocent parties from being caught up in this money forfeiture. So for example, if money is laundered and then it is used to buy something, then it can't be seized from the car dealership, let's say, if they had no knowledge that it was laundered proceeds. And I think that's the reason that the directly language is in there and is not in the drug forfeiture context.
So in my hypothetical where you have somebody who did not commit any crimes, put $100,000 in the bank, then stole the $50,000 ring, maybe changed it into cash for like only $35,000 because the ring was stolen, do you think that you could get at the $100,000, or would you be limited to the $35,000?
So it's very difficult, unfortunately, to sometimes untangle those proceeds.
That's
If you
why I
can,
tried to give you a very simple
sure,
example.
if you can untie them, then I think the Commonwealth would be limited. However, it's important to realize that this is a burden-shifting framework, and if the intervener can point to the, I could be wrong on your math, but the part that is not ill-gotten goods and say, here are my receipts, or here's where I got it from, or something like that, then they would be able to have a legitimate claim to it, and we would not be able to seize it for that reason. So I do think the standard here is relatively low for the Commonwealth.
And I take it you agree with him that because you're not saying this is a larceny, so we could get back the thing that was stolen, it is limited to money laundering.
It is limited to money laundering. However, I think because we have shown that he has a long career as a jewelry thief, we found lots of money that is unexplainable otherwise. That
Yeah, but did you cite any case law for that in that part of your brief? Because I did not see any.
No, Your Honor. I think that it's really about so if the Commonwealth's burden is that the money was probably derived from money laundering transactions, I believe ruling out other explanations makes it more probable that it came from money laundering transactions.
But so if they stole the $50,000 ring and let's say they even sold it for $50,000 and then they were using that to, pay for food or, a vacation, could you claim that?
So if it was tied up in the assets, I believe we would. So for example, with this Jeep, if much of the payments came from illegal money laundering, then I think we'd be forced to seize it, forfeit it, sell it, and then if there were remaining proceeds, I suppose they could argue that they would be entitled to some part of the sale after forfeiture, but that claim was not made here. Because again, I think all of this argument is in the Commonwealth's initial burden. This is in the burden of have we even established our case? And then the burden shifts to the intervener to show that they have some legitimate claim to it.
So if somebody stole something, the ring, and they got $50,000 and they just used that to pay rent and to pay for food, would there be anything for you to and you didn't, was there anything for you to seize as a result of money laundering?
I don't believe in that case there'd be any assets to be seized because it would all be gone at that point, if I'm understanding your hypothetical correctly.
So do you agree that what you need to show is reliable information in your possession that establish probable cause of the requisite nexus? That's sort of paraphrasing or almost directly quoting 2004 Audi.
Yes.
Okay.
Can I add one caveat to that? I believe it's also important to recognize that it can be with circumstantial evidence that, it doesn't have to be necessarily direct observations of that money laundering
Right,
transaction.
reliable information.
Right.
Right,
Sure.
okay. So what the requisite nexus is, in a drug forfeiture proceeding, it's all proceeds traceable to such an exchange of drugs for property or money.
Right.
In the money laundering statute, it's money or property obtained directly as a result of a violation of Section 2. That is, obtained directly as a result of a money laundering transaction. How
Right.
can you identify whether money or property is obtained directly as a result of a money laundering transaction if you don't identify the transaction itself?
I believe that the circumstantial evidence would make it clear that even if there were several transactions that led to the jewelry being converted to money, that each of those individual transactions would in themselves be money laundering transactions. There would be a different context if we had found the money in the safety deposit box of a co-conspirator or something of that nature. But because it's the perpetrator of the jewelry thefts that we found the money with, even if there were multiple transactions that occurred to lead to the money being in the safety deposit box, each of those in turn would be money laundering where he knows that they are the proceeds of crime.
And you maintain that you have proved that here in this case?
Yes, so I believe the circumstantial evidence, and I think that's where we get into the showing the lack of other legitimate assets, disproves some innocent explanation of it, and then the context of his long career of thefts. And I will point out as well, we aren't cross-appealing the jewelry that was found in many of these locations, but there was jewelry that seemingly was stolen, found in these locations that we aren't able to forfeit because it wasn't money laundered, but it does show evidence that it is potentially the hiding spot of the proceeds.
So let's assume somebody has $100,000 in the bank, no job, no wealthy parents, and I recognize this is a hypothetical.
Sure.
They plead guilty to money laundering $10,000, exactly, okay? And maybe they do have a lot of convictions in the past. Can the Commonwealth try to seize more than $10,000?
If the convictions in the past are money laundering that is unaccounted for, potentially. If the past convictions are not related to crimes.
Just assume they're all jewel thieves.
Sure. I think in that context, then, Your Honor, the Commonwealth will have met their burden. That does not necessarily mean that they would be
To
able
seize
to
more than 10,000?
seize more than 10,000 if there's
Even though the money laundering conviction was specifically for money laundering $10,000?
of the most recent conviction. But by your hypothetical, the past convictions, which have money unaccounted for.
There's no money laundering convictions, there's only jewel
Jewel thefts.
theft convictions.
But the previous jewel thefts, if the jewelry is still in the wind, as it were, I think we would have met our burden. That does not mean that we are entitled to forfeiture. We're only entitled to forfeiture if the intervener does not show entitlement to the res at issue. And so that's why I believe that Commonwealth's burden is relatively low, because there is a step.
So you're saying that the Commonwealth, to meet its burden, can rely in part on circumstantial evidence that there's no other explanation?
Yes, for meeting that first burden.
Okay, but isn't saying there's no other explanation essentially putting the burden on the claimant to come forward with an explanation, which they don't really do until you've made your initial showing?
I think that evidence is useful in both of them. I think that had we had no evidence of crimes, let's say, no evidence of jewelry thefts, and we just found somebody who had no innocent explanation for their money, then in that context we wouldn't be able to. But it's the lack of an innocent explanation in conjunction with a long history of career jewelry thefts.
So in this instance, Mr. Petrino says, my father had a lot of money, he set some aside for me, I never touched it, maybe I switched out some bills at some point. My wife was working. It seems like, however implausible those arguments may be, it can't be resolved on summary judgment. So how has the Commonwealth shown that there's a lack of any other explanation for these monies that were seized?
And I will admit the summary judgment standard is a little bit unclear on this point, but I believe those would fall into the category of mere assertions where essentially.
Well, it was testimony.
Right.
I mean, a mere assertion is something in a pleading that's not verified. That's testimony.
Right.
Growth, so.
Yeah, and I believe that, again, where the standard for the Commonwealth's initial burden is relatively low, that would be more relevant in the second prong, which is essentially not before this appellate court at this time, as you heard in the intervener's argument. So I think that as far as our initial burden, mostly what we're relying on is his career criminal, and then using, in addition to that, is ruling out innocent explanations for the money.
So you say you don't have to show any particular money laundering transaction because to get to where the assets were today, there had to be a lot of money laundering transactions.
Correct, Your Honor.
Can you identify a single one in the chain, sort of chain of title for each bit of property that was seized?
No, Your Honor. Unfortunately, we don't have direct evidence of the money laundering transaction, which is the goal of money laundering. Unfortunately, money laundering is meant to hide, to conceal from law enforcement, and to obfuscate it. The legislative intent was to capture this behavior. And
But they said you've got to show, and again paraphrasing or quoting 2004 Audi, reliable information in the Commonwealth's possession that established probable cause of the requisite nexus, which is that the money or property was obtained directly as a result of a violation of Section 2. That doesn't seem to be loose language. That seems to be a lot tighter than the drug forfeiture statute, which talks about all proceeds traceable to an exchange of drugs for money.
And I think that language, again, reflects the differences between money laundering and drug forfeiture. But understanding your point, I think that the circumstantial evidence is enough to show that a money laundering transaction occurred. Again, we are in a probable cause context.
Well, it's great to say we're in a probable cause context when you know that when the question is, well, you know, is the indictment supported by sufficient evidence, or is the complaint supported by probable cause? If there's ultimately going to be a trial where the Commonwealth's burden is beyond a reasonable doubt. Here, this reliable information that would tend to show probable cause is all the Commonwealth has to show.
And I think that summary judgment is usually the appropriate place for this first burden. I think that usually you get to a triable issue when you are on that. The Commonwealth has met its burden, and then there's a debate over whether or not the explanation is legitimate. I think more often than not, that's when you end up in a triable issue, as opposed to whether or not the Commonwealth has met its burden is a question of law. That
If you don't show a particular transaction that was money, you say was money laundering, then how can the claimant come back and say, no, that particular transaction wasn't money laundering, here's the explanation of it?
So I think that would essentially...
They've got to prove an awfully big negative if you've just kind of created a cloud.
So they would win on summary judgment in that hypothetical in the second prong. So we would have met our burden, but then they would have come forward with an innocent explanation, and then we would have no way to refute that.
But there was some evidence of innocent explanations here.
I think it was relatively minimal. I think it's not contested on appeal, and I think it essentially is disproven. It's self-disproving in a sense. So I think that's why summary judgment was appropriate in this context.
But you agree that a judge can't make credibility determinations on summary judgment?
Correct.
And Mr. Petrino testified under oath that he had legitimate explanations for at least some of this money.
Correct. And I think had this been a fully briefed issue, it would have been a very different context. But that issue was not raised on appeal, and I think that where this is a civil case, what is on appeal is relatively limited in circumstance.
So again, I just want to be clear about this. If somebody steals the $50,000 ring, they sell it for $35,000, and they put the $35,000 in a safe deposit box, is that money laundering?
Yes. They know that it is the proceeds of an illegal transaction, and they have attempted to hide it by doing a transaction.
By just converting it into cash?
Yes. They have made it less identifiable as the thing that was stolen.
You have to show their intent to do that, right?
Yes, and I think that
Or at least probable cause.
the probable cause of the intent, which is admittedly relatively difficult to understand exactly how that works, but my understanding is that probable cause of the intent can be proven by the context of the transaction that likely occurred and where the money ended up. And I think here, where it's in a safety deposit box, hidden throughout the houses, I think that makes it clear that this was meant to be hidden.
So if they plead guilty to larceny and the Commonwealth agrees there's no other crime in relation to that theft, is that money laundering? Could you seize this under the money laundering statute where the Commonwealth agreed we aren't making any other charges, you plead guilty to stealing the ring?
I think in that context, Your Honor, it would come down to the differences in the burden between the criminal context and the civil context. A prosecutor may choose not to prosecute a case for any number of reasons in a criminal context, such as that they couldn't meet the higher standard in a criminal case, whereas in a civil case, the standard is significantly lower. And so even if
So you don't need a conviction for money laundering to pursue money under this statute? That's your
correct,
position?
and that's the case law in the drug forfeiture context as well, is that we do not need to pursue a conviction to forfeit the money.
May I ask one further question? And it's, I think the first question that I asked opposing counsel, was the Commonwealth proceeding here on a theory under subparagraph 2 of 267A2, the engaging in a transaction, or was it under subparagraph 3, directs, organizes, finances, plans, manages, supervises, or controls?
I think the answer is both. I think in this context, because we are relying on circumstantial evidence, and we are in a lower standard than a criminal context, that we are essentially saying it was one or the other. It likely.
So you don't even have to specify your theory of money laundering?
Had we gotten to the point past summary judgment, I think we may have, but I think in this context, where it's about whether the Commonwealth.
Why would you have to do anything past summary judgment? It's for the claimants to meet their burden. Again, this is not a criminal trial where just showing probable cause, even if it's a lower standard, ultimately you have to prove beyond a reasonable doubt. Here, if you show this reliable information of probable cause, then that could be the end of the case for you if they come up with nothing.
My apologies, I misunderstood. I think had this been a criminal case, we would have proceeded under both theories and let the jury decide which one was appropriate. I think the circumstantial evidence would be sufficient to prove both theories in this context. So I think under this one, we are proceeding under a general money laundering, which could encompass both types of behavior.
And
You
did you
didn't-
specify in the trial
You didn't
court?
raise that. You didn't raise the paragraph 3, I think, in the Superior Court, correct? And the judge
I don't
didn't-
believe that
the judge
anybody.
didn't rely on that either.
I don't believe either party below discussed the nuances between the different types of money laundering, and I don't believe the motion judge ruled on the distinctions between the types. And again, I think mostly that is because we are relying heavily on circumstantial evidence that a money laundering transaction occurred, and so knowing the exact details of that money laundering transaction is difficult in this context.
Any other questions? Okay. Thank you very much. We'll have to
Very
leave
much.
it there. Well argued. The next case today is 2024 P1425, ALAN ANTOKAL, and another versus the CAPE Club of Sharon, LLC. We'll be hearing from Attorney Shaw first.
Good morning, Your Honors. May it please the Court, I'm Robert Shaw from Holland & Knight, and I represent the appellants, 25 TO Holdings, LLC, and the CAPE Club of Sharon, LLC. So back in 2014, the plaintiffs were named as defendants in a TIPS Act class
We
action.
understand the factual background. I'd really encourage you to get to the heart of the legal matters.
Okay. They were named in a class action. It was an $18,000 case.
I'm going to
The
move you.
club,
Okay.
no, I'm moving along, Your Honor.
So,
The club
okay, you
faced-
keep saying it was an $18,000 case, but their exposure was $1.2 million in damages that could possibly have been troubled plus attorney's fees, right?
The amount of unpaid tips in the case, alleged in the complaint, was $18,000 in unpaid tips. And at the time of the sale.
So you think they're not telling us the truth when they say the exposure was $1.2 million?
That's what the case looked like. That's what the complaint looks like in the TIPS Act case. It
Okay,
says
and-
$18,000 in unpaid tips.
All right, and to be clear, you're not contesting that your clients were successors in interest of the former club, and you're not contesting the jury verdict that your clients have liability for negligent misrepresentation, correct?
That is correct, Your Honor.
Okay.
And so, during what happened was the club fell into financial distress, and one of the former presidents sat down with an agent of 25 TO, and they decided to enter into a deed in lieu of foreclosure where the real estate from the club was transferred to 25 TO, and the debt was paid off. There was no transaction directly between the plaintiffs and the defendants in this case. There was a deed in lieu of foreclosure between the club they
Right, there was a
led.
transaction that involved at least the second president involving transferring the real estate, and his testimony, which I believe the judge credited, was that he would never have done the deal if it did not include indemnification, right?
That is correct, Your Honor. And so what the trial judge did below was found that this negligent misrepresentation made in this meeting, which was, will 25TO indemnify or honor the indemnity contained in the CAPE Club's bylaws after this transaction. And this small seeming case, insignificant in the scope of a $6 million land sale, some unspecified assurance that this indemnity would be honored was
Your
made.
client had like a year and a half to settle this insignificant case and didn't, right?
My client wasn't driving the bus here, but be that as it may, we have some negligent misrepresentation. That's all the jury found.
Right,
But
so
Your
I'm going to
Honor, sorry.
move you along because we're really going to run out of time
Okay.
here, and that's going to be frustrating. I will grant you that they didn't paint the clearest picture, but it does seem like they put enough in their brief to say what happened here was that your client transferred all the advantage, your client did get an advantage, like in Anthony Pier 4, by not continuing to pay the attorney's fees. They transferred $500,000+ of an attorney fee burden over to their clients. And so there was an advantage. It was more than just the negligent misrepresentation a la Anthony's Pier 4. And your client ended up paying this attorney, by cutting off the attorney's fees, ended up paying, 5 figures probably. It was very hard to tell. And pushed $500,000 worth of attorney's fees onto them. That's going to be their argument, would be my prediction. So I don't
Your
see a
Honor.
response from you about that.
Your Honor, what the jury found was a negligent misrepresentation. It also
The
found...
judge is not bound or limited by the jury, right?
I understand, Your Honor, but the judge didn't reach any differing conclusion either. What she found was specifically, based on the negligent misrepresentation, I find a violation of Chapter 93A. Now, there wasn't a finding that it was an extreme or egregious misrepresentation. There was no comment or finding about my client's state of mind at the time these assertions were made. There's no indication that he believed that this indemnity wouldn't be honored. Imagine, as a hypothetical, Your Honor, if instead of making some negligent misrepresentation that the indemnity would be honored, he swore in a contract, signed, sealed, and delivered, we are absolutely going to honor this indemnity, and then failed to honor the indemnity. That would be a breach of contract. But typically, on its own, standing alone, would not be a violation of 93A. Even if it was a central and inducing feature of the contract, that's just a material breach of the contract. So here you have a finding of negligence, the judge finding no willful conduct at all, except the willful refusal to pay.
Right, and there's definitely some force to your argument, and it may in fact prevail.
Okay.
But my concern is that what this does is allows the client in your position to get away with shifting $500,000 plus in fees. It does get a benefit. It's not just a not performing. They're literally moving money over to somebody else's column. And that's why I'm saying, why is that not an Anthony Pier 4 situation? Is it because he didn't say, ha ha ha, I'm doing this to get some better deal out of them?
But Anthony Pier 4 would be a breach of the duty of good faith and fair dealing. And we have here, there you had a contract, and there was an implied term in Anthony Pier 4 that says you'll do nothing to deny the other side the value of the benefit of that contract. And the damages sounded in ordinary contract damages. We're not denying ordinary contract damages here. We're standing in the shoes of the CAPE Club today saying that we are responsible to pay for, we're not trying to deny the indemnity. What we're here to argue over is whether those damages should be enhanced, should be tripled, and whether they should get prevailing party attorney's fees for the case below, not the case they lost, the class action they lost and generated, I think, $575,000 roughly in fees in. They should get paid for that. What we're saying is that triple damages and attorney's fees for the case below was not warranted based on merely a finding of a negligent misrepresentation. This was a knowing and willful violation of 93A, but the trial judge doesn't point to anything that's willful in this record at all, other than the willful refusal to pay. And so I saw that and said, well, that's a breach of contract. People willfully refuse to pay their obligations every day. The other thing that stood out when I read this record was the way that the analysis is inconsistent, in that my client stands in the shoes of the CAPE Club because of this successor liability, this de facto merger or mere continuation theory. That's the only reason my client, 25TO, is liable under this indemnity. It's because we are the CAPE Club of Shannon. And I saw that and I said—
No, it seems like there's a second theory, which is that your client made this negligent misrepresentation as part of the land transaction. That seems like it's a separate leg.
And then, but the damages for a negligent misrepresentation would be what followed from that misrepresentation, what reliance it induced. Here, what they're enforcing is the contractual obligation in the CAPE Club bylaws to pay for that case in particular. And that's the legal theory under which they operated. It's what the jury found. And from my perspective, it seems that the analysis ought to be consistent. If we are the CAPE Club of Shannon, then this is a dispute between the CAPE Club of Sharon, I'm sorry, I meant to say Spring Valley, I misspoke, between Spring Valley and the plaintiffs, who are the former presidents of Spring Valley. And they're suing us because we have refused to honor the indemnity in the Spring Valley bylaws.
Right.
And that's
So,
a prototypical
excuse
me, Your Honor.
Is this your intra-enterprise
You've got it, Your
argument?
Honor.
All right, but at the time the negligent misrepresentation was made, your clients were not Spring Valley. They were making the representation, negligently it was found, to the presidents in order to induce them to go along with the transaction by which you stepped into the shoes. But you weren't in the shoes yet.
You're absolutely right, Your Honor. It's just when you look at the trial court's analysis, it's trying to find a 93A violation in here. And it says you have the jury's finding of a negligent misrepresentation, and then you have the willful refusal to pay. He knew he had to pay, but he didn't pay, and that's the 93A violation.
Okay.
I represent to you that that was when we were standing in the shoes of the CAPE Club, and by that point, it was an intra-enterprise dispute. That maybe the misrepresentation was as part of a— The other thing, beyond just the inter-enterprise, to sustain a claim under Section 11, you have to have some sort of transaction between the parties. The SJC has made this clear several times. And there's no transaction here between us and them. That's the unusual thing about this case, is that we didn't buy any—
There's a representation to the presidents, which the presidents, especially the more recent one, relied on in allowing this transaction to go forward. He might not have been a party to it, but I mean, he was president of Spring Valley at the time that Spring Valley agreed to have this note acquired or agreed to the foreclosure, so.
That's correct, Your Honor. But I guess what I'm looking for is in this—
It's a transaction. What case says that the plaintiff has to be a party to the transaction?
Well, there has to be a transaction between the parties. The SJC has said that. The other thing is that the trial court analogized to the sale of a business context. And in that, the prototypical sale of a business is that they own the business and we are buying the business from them. But that's not what happened here. We didn't buy anything from them.
No, but you took all the assets, and so he asked you for the name of the case. You keep saying there's an SJC case, so there are a lot of SJC cases.
Oh, I'm sorry.
Do you want to give
Yes.
us a hint?
On inter-enterprise disputes requiring requiring a transaction. Give me 10 seconds, Your Honor, I'm sorry. So it's Rafferty versus Merck & Co., 479 Mass. 141. And Section 11 requires a commercial transaction between the parties.
All right, I want to take you back to the willful and knowing for a minute.
Please do.
Because you and your colleague on the other side seem to disagree on the standard of review. So you can leave us to figure that out, or you can explain to me why they're wrong. But you seem to argue de novo, and they, of course, are arguing whether the 98-3A violation was willful or knowing. They're arguing it's just an abuse of discretion. So why are they wrong?
The maneuver they make in their brief is to try to recast are legal arguments as attacks on the factual findings of the court. And I want to make it very clear, we are not questioning anything that the trial court found in its decision whatsoever in terms of the factual content. But the question is, do those factual findings, that is, he made a negligent misrepresentation and 25 TO, willfully refused to pay. Do you put those two things together and get a knowing and willful violation of Chapter 93A? And that's a legal question, as far as I'm concerned, Your Honor. So that's why I say de novo.
The judge does a little more.
Please.
That says, given plaintiff's credible testimony that the deal, which is the land deal, hinged on their continued indemnity of which the defendants were aware, the defendant's later refusal to follow through on that agreement is inexplicable and falls within the realm of unfair practices that 93A was designed to deter. Is that more than a finding of negligent misrepresentation by the judge?
No, Your Honor. And even if it were a finding that this was material to the, I read that and I think it says that this is a material element of the contract. And let's imagine instead of a negligent misrepresentation, I'll bring you back to that hypothetical, there was actually a contract here, and all they're saying is, we would never have done the deal if that provision hadn't have been in the contract. And I'm saying, okay, it's a material breach, but a material breach is not a 93A violation. And I think that is a de novo review, Your Honor, just because the facts are not in dispute. The question is, what are going to be the boundaries of 93A? Is this statute has it devolved to the point where it's, all-purpose damages multiplication vehicle? Or are we going to put some bumpers around the edge to police how far the discretion runs on enhancing damages? And I think it's an important public policy question.
So our time is running short. On the attorney's fees, that you did not argue the reasonableness in a pre-verdict motion. You've argued that in a post-trial judgment notwithstanding the verdict, that the attorney's fees had to have been reasonable. They say we can't even consider that. The issue's waived. What's your best case that we can consider it?
Your Honor.
You agree with that factual?
We did not brief it in our reply brief because I wasn't trial counsel, so I was unaware of the ways in which it was not preserved, and I agree with their argument, so we didn't take it up in the reply deliberately.
So
I want to focus the court.
Does that mean an agreement that it was waived below?
Exactly, Your Honor. Sorry. And I just want to focus the court on the core issues in this appeal are, was there a 93A violation to begin with? Was it willful and knowing? And was this an intra-enterprise dispute? And then the last one would be, was there any underlying transaction to be able to support a Section 11 claim at all?
But you agree that there was no point in time where the presidents of the club were simultaneously part of the same enterprise as your clients, right? You're saying they were successors to Spring Valley.
Yes, although I would say that the alleged unfair and deceptive trade practices, as outlined in the complaint, as I was arguing to Justice Sachs, occurred after we were the successor in interest. So, it is, in my mind, Your Honor, this is a case of the former presidents of the club suing the club, me today, for indemnification under the club's bylaws. And that case would never sound in 93A in any other situation. The strange thing about this case is that, if it were more cut and dry, if it were just a contract, no one would be thinking that this is a 93A case. It is only because it's got these weird nuances. Okay.
I think we'll have to leave it there.
Thank you, Your Honor.
Attorney Schroeder.
Morning, Your Honors. Donald Schroeder and Morgan McDonald Ramos on behalf of the plaintiff appellees in this case. And I'll cut to the chase, Your Honor, because I was listening.
Thank you.
This case boils down to, this is not a typical breach of contract case. Having been legal counsel on a variety of two of these litigations for the entirety of it, from 2014 all the way up until now, it boils down to plain and simple, bad people do bad things. This is a nightmare scenario for anyone who has volunteered in an official capacity on a board or in an officer role. You're told you're indemnified, then you're not, and now you face a lawsuit that could potentially bankrupt you personally.
And as a result of the decision, they're getting their indemnification for their fees, right? The issue here is trebling and attorney's fees to the litigation itself?
Correct. And so one of the issues, Your Honor, that I think it boils down to is whether or not there's more in the record than negligent misrepresentation.
And you in your brief say that the more is the failure to pay the indemnification.
No, Your Honor, it's not just the failure to pay the indemnification, it's the misrepresentations that were done before the transaction
Okay, well, that's
that
a
occurred.
negligent misrepresentation, but an element of negligent misrepresentation is pecuniary loss to the person who relied on the representation. So I don't see how saying there was negligent misrepresentation and they refused to pay adds anything to the negligent misrepresentation. You don't have negligent misrepresentation unless there's a refusal to follow,
Right.
unless the representation turns out to be false.
Right, and that's where I would like to
What's
focus
the
the court.
more that turns this
Absolutely.
negligent misrepresentation into a 93A?
First, I would say a couple of things, Your Honor. They like to make the argument that somehow Mr. Antosha's comments and representations, there were 3 times where the Judge Kazanjian found he had made these representations. And they liken it to a bad prediction, like predicting the weather. And I'd like to point out not just the facts in the record, but also Judge Kazanjian's factual findings. On multiple occasions, Mr. Antosha represented to Mr. Robinson that the Norrell lawsuit would be covered by defendants. Mr. Robinson testified that it happened on 3 occasions. He was credible, forthright. The judge found him to be so. Carol King testified she was present for at least one of those discussions, J8, Joint Appendix 862. Mr. Antosha was found to be not credible, including his lawyer, his longtime 30-year lawyer who testified was found to be not credible. This goes to the issue of whether or not there was intentional misrepresentations, not whether or not it was pled that way, but whether or not it's...
All the jury found, and the judge didn't go further, it seems to me, is that there was a negligent misrepresentation. So how can we find a fact on appeal that there was intentional misrepresentation?
Judge, I think you can look at footnote 4 on, or footnote 5 on page 4 of her decision in June of 2024. And it states, and this is something that's glossed over by counsel, quote, Antosha testified at trial that Robinson never told him about the Norrell case prior to the sale, and that he never promised to take care of it, as Robinson testified. Shelmerdine, who's the 30-year lawyer for Mr. Antosha, testified to the same effect. The court did not find their testimony to be credible generally, and particularly on this subject matter. Moreover, as to Antosha, his trial testimony conflicts with his deposition testimony, in which he stated he did not remember if Robinson had told him about the prior lawsuit. Likewise, it is clear from the verdict that the jury did not credit their testimony either. In the judge's order, she actually does state, contrary to what was stated earlier, that she found this conduct egregious. And part of the reason why it's egregious is when you look at the successorship liability issue. I realize they concede on that now, but what's important about that issue is the fact that Mr. Antosha, if they concede on that issue, which they have, he was the agent of those 2 defendants. He knew when he made those representations that he was never going to follow through on that. And in fact,
well, egregious is a label. What conduct was egregious?
Well, the egregiousness goes to the issue of, I made these misrepresentations in order to make this transaction happen, right? And then you get to the issue of, well, can you have egregiousness when it comes to negligent misrepresentation? There's case law, the in-ray TJX companies, if it's on a broad scale. Now, I would say that this misrepresentation relates to payment of attorney's fees, arguably occurring over a broad scale given the length and complexity of the litigation. He did it on 3 occasions. But he also controlled the narrative, and this goes to the issue of egregiousness and whether or not when the truth could have reasonably been ascertained, and why successorship liability and that issue is really important, because Mr. Antosha was the gatekeeper on all financials. He understood anything that happened in this transaction, which, by the way, in the reply brief is referred to as $6.18 million transaction. So there's certainly a transaction. I can certainly address the intra-enterprise dispute issue separately. But here, what does he do? He makes these representations. Judge Kazanjian finds that when Robinson, on page 4, when Robinson told him about the Norell litigation, Intosha responded that the Norell case was not going to, quote unquote, not going to be a problem. Then there was a meeting with Intosha and Shelmerdine. Intosha repeated his commitment that he was going to take care of it. The promise was repeated at a meeting with Carol King. King testified that Intosha did not seem fazed by the lawsuit and said his group would absorb the lawsuit as part of the sale. Why are these representations intentional? If you look at the trial record, specifically the testimony by Mr. Intosha and his longtime attorney, Mr. Shelmerdine, you'll see that 2 years earlier, prior to this transaction in 2016, Mr. Intosha had signed a consent judgment with the AG's office relating to a nearby development in Sharon, which resulted in the repayment of hundreds of thousands of dollars in deposits to burned homeowners. Defendants purposely used Stephen Robinson as a pawn in the face of Spring Valley to hide Mr. Intosha's involvement on the building of 50 multi-million-dollar homes.
Mr. Intosha behaved discreditably in other transactions, but the question is what he did here. I'm looking at the judge's decision, page 12 of her decision, Record Appendix 1719. She says, applying this legal framework, defendant's negligent misrepresentation, as found by the jury, is sufficient to support a finding that defendants violated 93A11. I don't see where she says, I find, contrary or on top of what the jury found, that this was an intentional misrepresentation.
Well, she took it upon herself, Judge Kazanjian did, because she has the right to, as the judge, to decide the 93A case.
Oh, absolutely.
Absolutely,
Absolutely, but
afterwards.
she didn't go beyond what, she had an opportunity to and a right to go beyond what the jury did, because she heard all the evidence, but she didn't. She just said the negligent misrepresentation is enough to support a 93A violation, and that's what I'm having a problem with.
And I understand that, Your Honor. However, what this case is really negligent misrepresentation plus. Could she have gone into all of the detail here? She does go further.
That's a pretty important detail. She gives really one paragraph to the issue, and she never says it was an intentional misrepresentation.
Well, what she does say, Your Honor, is that further down on page 12 is that defendants clearly understood that when the transfer occurred, they would be subject to liability for the Norell case. And that's the issue, is that because of the successorship liability being conceded, Mr. Intosha controlled all the action. It wasn't like he was relying on anybody else. He made those misrepresentations. He knew when he made them, and the course of his conduct, which was all in the record, whether it's his bankruptcy previously, whether it's his consent judgment to the AG, whether it's the Town of Sharon meeting board minutes.
Okay, but then let's go to his strongest point, and because you both have risk here. And his point is, look, even if they had expressly said in the contract, we're indemnifying you, and then they breached that's not enough for 93A liability. And there are some threads in your brief to say, well, shifting costs is enough for the 93A liability, but that's not the clearest argument. So are you making that argument, number one, and why is he wrong about his hypothetical?
Well, because I think what we're living with is the reality of what happened here. And the reality is that Mr. Intosha and Spring Valley, or 25 Tiat Holdings and CAPE Club of Sharon, knew that they had legal obligations from the get-go.
Right, so if there was a contract that said, we'll indemnify you, and then they breached, he's saying that's not enough for 93A liability. Why is he wrong?
But here, that's not what happened. What happened was
Right, you had less than a written contract.
I understand that, Your Honor, but here what it relies on is the intentional misrepresentations that he made to get Mr. Robinson to do the deal. It's clear in the record that Judge Kuzanjian has said this deal wasn't going to happen. Mr. Robinson wasn't going to do the deal unless he knew, hey, you're going to take care of the indemnification. Yeah, I'm going to take care of it, I'm going to take care of it, I'm going to take care of it. He made all those representations knowing full well he was never going to do that. And that's the intentionality and misrepresentation.
Okay, but we're going to stop you there. Let's assume for the moment that you had a written contract that provided for indemnification, and then they knew that was important. That's why it was negotiated and put into the contract. But then they just breached. why would there be 93A liability in that hypothetical scenario, which I know you're saying is different?
Well, I think there would be a breach of contract claim, and here there was a breach of contract claim.
Right,
It
but
was
why would there be 93A liability?
Well, because the underlying record in this case and the testimony by Mr. Antosha and Shelmerdine, they were found to be not credible by the judge. And so those were intentional misrepresentations. If they're not credible, then somebody's not telling the truth, right? And Mr.
So the key to the 93A violation is that these were intentional misrepresentations.
Yes, Your Honor.
But the judge never uses that word, does
Well,
she?
she says that they were egregious, and it's inexplicable that the,
So what she says is, it seemed to me what she was saying was egregious was the inexplicable failure to pay, which is an element of negligent misrepresentation in this circumstance.
it's an element of negligent misrepresentation, but there is case law that says if it's extreme and egregious, it rises to the level of 93A liability.
Egregious. The defendants weren't using it that we've seen to extract some additional unfair advantage from your clients.
What's egregious, Your Honor, is that, and this goes back to the successorship liability issue, they assumed at the time the level of bad faith by these actors, Mr. Shelmerdine, Mr. Antosha, was palpable.
Yeah. So why was there never an intentional misrepresentation claim in the case?
Well, I can't tell you why today there was a negligent misrepresentation, but you could still have conduct separate and apart from that, even if you don't have the intentional misrepresentation claim, to say that it supports 93A liability here. And here, they assumed all sorts of, they cherry-picked which liabilities they wanted to assume, and the one they didn't assume, even though they knew it, even though they had the bylaws, was this issue of indemnifying the plaintiffs. And why do we know that it was intentional? Is because later, even though they had, and Justice Henry referred to this, they finally hired a lawyer for the club that rode the coattails of Mr. Robinson and Antokal's counsel 6, 7, 8, 9 months before trial, and they tried to do a Monday morning quarterback at this point. They knew they had to have a defense at that trial. They had somebody there to attend the trial and deal with witnesses and cross-examine witnesses. But it goes to the issue of the intentionality. They knew they had this obligation, and they just once they got what they wanted, and here this goes to the intentionality and part of the bigger picture, they had to go in front of the Town of Sharon board. And when Mr. Shelmerdine is asked about that, we went through the Town of Sharon board meeting minutes. And there it's, one of the chairmen says, well, why is, I noticed that Mr. Antosha was CC'd on this one email. He's involved in this, and why didn't you tell me about it? Well, we didn't tell him about it because it was intentionally left out. They had Mr. Robinson up there in the fall of 2016 to be the face of Spring Valley. And as soon as they got their zoning and permits done, at the end of 2016, Mr. Robinson is no longer spoken to by anybody at the club. So it is part of the totality of the circumstances, Your Honor, when you look at the entire record, that this adds up to willful and knowing. Not just willful or knowing, willful and knowing. And in fact, the judge does say that and says it's egregious. Would the justice like me to turn to the inter-enterprise dispute?
Well, I want to stick just with an example where there's an express provision in a contract that they'll indemnify and then they don't. Can that be a 93A violation?
Not standing alone, Your Honor. I don't think it's standing alone is a 93A violation, but that's not what this case was. And what transpired was there was no contract. I mean, there was a transaction. The deed was signed over in lieu of foreclosure. And as Mr.
Are you arguing that them just shifting the attorney's fees onto your client would qualify as like a Anthony Pier 4 situation? Are you more that it was an intentional misrepresentation?
I do believe, Your Honors, that they knew, obviously, that these two individuals were volunteers and that they were potentially on the hook for many, many dollars. This was a wage and hour class action.
So he says, though, that the complaint only sought $18,000 in wage and hour.
Completely untrue, Your Honor. I actually litigated that case and tried that
Is there a record
case.
site for you then on that?
I'm sorry?
Is there a record site that it's
There is a
not-
record site. I think it was Stephen Robinson testified to Stephen Robinson testified to the fact that the potential damages were $1.2 million, and obviously trebled, that gets to $3.6 million. That is JA 762 to 763.
Okay.
And that was what happened in that case. The judge in that case allowed 12 different chalks of potential wage violations for a 5.5-year period to go back with the jury. So it's a 5.5-year period.
We're going to have to leave that there. Let me just see if anyone else has any other. Okay, we do understand your arguments. As I said, you both, make forceful arguments. You both have exposure, and we understand your positions, and the case is submitted.
Thank you for your time.
Our third case today is 2024 P1349, Tracy E. Fern and another versus Anthony W. Baker and others. I think we'll hear first from Attorney Fulginiti.
May it please the Court, John Fulginiti for Tracy Fern. Timothy Brawler is with me. I would like to start with the second argument briefed. All of the gifts must be invalidated on the basis that there is no donative intent on behalf of the principal, the decedent Francis Fern. The decedent Francis Fern.
Are you saying that the judge's finding of donative intent was clearly erroneous?
No, there is no evidence on the record to support. Very specifically, the judge uses the single word intention used in the judgment was in the words clear meaning of a possible future action to be considered, what one might do. The decedent said she would address gifting in the future when she slowed down. The findings at 118, 119, the transcript, 905 and 1123, very clear that there was no donative intent. She would review gifting when the time came for her to slow down. She had some thinking to do about that. When her life was winding down, she would address gifting.
Right.
She didn't feel that way at that time.
And Anthony says, well, but what if you aren't able to make a decision at that time? And she says, I trust you and Chris to make it. That's
still not donative intent. That's not a record of donative intent showing that she intended to have these gifts of $5.6 million given. If you look
do you
at,
agree that the existence of donative intent is a question of fact? Just so we're kind of get the ground rules straight here.
absolutely.
And so do you agree that the judge found donative intent?
No, he doesn't. Donative intent actually, remarkably, doesn't show up once in the entire record. Only the word intention is used, and it's used specifically with respect to a possible future action to be considered, and that's what the evidence supported. And the most significant fact, Your Honor, that shows that is when Tony Baker, the whole conversation that starts gifting is based on the subject of the passbook savings account, and he asks his mother what her intention is regarding that passbook savings account that was closed in 2012 and not opened again. And this conversation happens in March of 2013. And when asked what her intention was, she answers, quote, she hadn't decided, transcript 901. If she hadn't decided when she specifically asked about a $200,000 passbook savings account that he's asking if it's in her intention to gift, she certainly doesn't have donative intent for $5.6 million in gifts. And in addition, Edelstein instructs that in addition to looking at her statements, you must also look at the conduct. The last two checks that she wrote to Tony Baker and Chris Baker for their birthdays in March and May of 2013 were $100 each. She had no history, no pattern of giving, which Edelstein looked at both specific statements of donative intent and a course of conduct. Neither of those exist. In addition, you have the complete conflict with the estate plan, and Tony Baker's own words, with respect to what his mother wanted, she said that she feels she loves each of them equally, she is proud of each, that is the right thing to do, and that is her plan, and that's exactly what her last will did.
Counsel, on Record Appendix 99, the judge's findings, 148, Anthony testified it was easy to decide on the recipients of the gifts because the decedent wanted gifts to be made to the people there with her at the end of her life. He testified there were only 3 people in her life, himself, Christopher, and Ms. Laporto. And the judge goes on to summarize and state what the testimony of Anthony was, and that he testified that Tracy was not part of the decedent's life, decedent not wanted to reward her, and he then goes on to say he believed that if the decedent were competent, she would have chosen to make gifts at that time, and that he testified credibly that the decedent did not like paying taxes, and doing so, would ruin her entire month each year. So the judge ends that paragraph by saying that the court credits that testimony.
The facts are, that's applying a substituted judgment. The facts aren't there to support the donative intent that's actually necessary for the gifts. And that's actually made quite clear with respect to Gagnon and Restatement Second 33 and 385, that even in no event must the agent act contrary to what the decedent has requested, and she was quite clear that this was something she was going to address in the future. So to say that I knew exactly what my mother would have done, does that finding by the judge is not supported by evidence of donative intent to make these gifts, and that's also supported by the complete lack of a pattern of conduct and being in conflict with the estate plan, which I suggest is the judge also made an error with respect to the standard to apply, which is heightened scrutiny and careful scrutiny, given that the...
What does that mean in practice? You're not saying that it's above a preponderance, right?
No, what I'm saying is, and based on those cases, is that since this is a self-dealing situation, they're in the position to create the proof, some type of independent corroborating proof other than their own statements to support.
You're saying heightened scrutiny means there needs to be something more than the testimony of the agent or the fiduciary who benefited.
Absolutely. There's got to be some type of corroboration. That's what, in fact, this goes hand in hand, Your Honor, with the fact that the careful scrutiny required under the state of Sharis is the fact that the principal in that case was enfeebled by age and disease, not incompetent. But the idea is these matters couldn't be discussed with Frances Fern at the time that the gifts were made, and so that heightened scrutiny and that careful scrutiny is necessary, and there needs to be some type of corroboration.
Okay, but does that heightened scrutiny need to take the form of a rule? All I see is that I don't see a case that says that a fiduciary's transaction that results in a benefit to the fiduciary must be supported by something more than the fiduciary's own testimony. I see some instances in which the fiduciary's testimony was found insufficient, but I don't see any court, and multiple courts have talked about heightened scrutiny, careful scrutiny. I don't see anybody laying down a rule.
I think it's highly suggestive in the estate of Moretti.
Are you asking us to lay down that rule?
Yes, I think it's highly suggestive in a state of Moretti.
If we don't agree with you about the rule, do you still win?
Yes, absolutely. There's insufficient evidence, even without the heightened standard, to support donative intent. It would overturn all of the cases, even if considering donative intent for a joint savings account. There's nothing here that suggests that she was ready to make these gifts. The statement by Christopher Baker, which is at the time with the CPA, is that she didn't feel that way at this time, certainly.
So your position is if there's no history of giving, and even if there is a history that she didn't want to, give excess taxes, that there can't, at a certain point when she becomes not competent, there just can't be gifts anymore?
Without any donative intent that she wanted the gifts made, without a pattern.
You're saying she couldn't have even they couldn't have even done gifts equally between all three children?
Correct. That's right. There's no donative intent for any gifting. They could have filed a petition under 201-38, I believe, to establish a specific estate plan to make the gifts, and that judicial consideration looks at factors different than donative intent, but not with the power of attorney. Yeah, they could not do that. You have to obey the intent of the principal, even to the point where if the principal contradicts, not this case, but contradicts the agreement that was made with the agent, you always have to abide by the intent of the principal.
Right.
And
So,
here it's...
Would you agree that the power of attorney allowed gifts to Tracy, even large ones?
Do I agree that it allowed gifts?
We're just looking at the power of attorney itself. Does it grant authority for gifts to Tracy? Even if it doesn't grant authority for gifts to Tony and Chris themselves?
Well, I think that issue has to be broken down, Your Honor. First, which I'd like to get to in a couple of minutes, is the separate issue of whether the power of attorney itself expressly allows self-dealing to the agents themselves.
Okay, but my question was, a gift to Tracy wouldn't be self-dealing. Does the power of attorney grant, in talking about the power to make gifts, would that allow for a gift to Tracy?
It would allow the authority. There still needs to be donative intent, and there still needs to be, the gifts would have to be made under the...
Okay, so what case says, or what authority says that where a power of attorney expressly grants the power for a transaction, such as gifting here, there must be additional express language to allow the transaction with the fiduciary, himself, herself, whoever?
Oh, well, absolutely, Gagnon, for sure. The issue there is that the judge completely distinguished away the Gagnon case based on the first holding, which was that the power of attorney was revoked. But that case stands for the overriding fiduciary duty of undivided and absolute loyalty and utmost good faith.
I don't see where Gagnon says that there must be additional express authority for a transaction with the fiduciary.
Well, that's also part of Gagnon. That would be Gagnon and the references to Restatement 33 and 385, which is that there has to be clear direction from the principal as to the act that's requested. So there has to be donative intent for the transaction on behalf of the principal.
Right, and obviously in Gagnon there was strong evidence after the father, I think, had engaged in some transaction with the real estate that wasn't intent to allow the daughter, the power of attorney, to do that. But here we don't have any, I'm really asking about the authority granted by the power of attorney itself as distinct from donative intent, which I understand is a separate question. Is there any case that says once the power to engage in a particular kind of transaction is granted, then there must be additional express authority in the power of attorney to allow the fiduciary to conduct that transaction with the fiduciary itself?
Not stated that way, but stated differently, and that's our second argument, is the fact that there has to be undivided and absolute loyalty, and you have to act solely on behalf of the principal. And the error of law that the judge makes in that case is when the lower court states on page 36 of its judgment that since Tony and Chris Baker proved that the gifts were authorized by the power of attorney, which is the point you're making, they could use the gifts as they wished. That's a clear error of law, because by definition it applies no consideration to what the gifts were used for, and it's in direct conflict with Gagnon footnote 11 and restatement 387, because even if expressly authorized by the power of attorney to act, it's irrelevant if the authorized act is done for an improper purpose. And in this case,
But why would be, if she wanted to give gifts to minimize her estate tax liability, then why does it matter what the recipients of the gifts used it for?
well, first of all, there's no evidence on the record that she actually wanted that. She said she would address gifting in the future. And in this part of Gagnon, footnote 11 and 387, requires you to look, because in this case, it's undisputed that the agents gifted themselves $3,250,000 to make an all-cash offer of $3.3 million 1 week later, at the time the gifts were made, and there were no gifts made in 2014, 15, or the first half of 16, and you have Tony Baker saying that he didn't have to sell his Apple stock. He acknowledges that without the gift, I probably would not have liquidated my own funds at that point in time. I probably, in my decision for my portion of the joint ownership, I would have done it in a different way, probably at a different time. Yeah, transcript 840. So there's the whole reason for this area of the law is based on all three of those factors. The money being used for the purchase of the house, that's when the gifts were made, so you're looking at the timing. 2, the fact that he didn't have to sell his stock. And 3, that no tax savings gifts were made in all of 14, 15, and the first half of 16. All of that goes to the fact that it's an improper purpose that the gifts were made, and that was the judge's error in his statement when he says it doesn't matter what the gifts are used for. But by definition, you could never determine if there's an improper purpose if you didn't look at what the gifts were used for.
You assert that the language that provides the standard for gifting here, which is gifts to those who, in my attorney's opinion, would be the donees I may choose. You assert that that's meaningless verbiage, like to whom the power of attorney deems most advantageous. Is that
No, there has to be donative intent with respect to applying who the gifts are going to go to, and there's also a duty of loyalty.
I'm asking, you talk about restatement comment H, and you talk about meaningless verbiage being disregarded. Do you think that the standard that's in this power of attorney, gifts to those who, in my attorney's opinion, would be the donees I may choose, is meaningless verbiage that doesn't?
I didn't understand if you're saying meaningless verbiage with respect specifically to whether there's self-dealing authorization. I didn't understand that that was part of your question. Absolutely, it's all-encompassing language as defined by Gagnon's reference to the restatement, which is, it's just broad verbiage, and it's not explicit. Explicit language allowing self-dealing would be, this power of attorney specifically authorizes my attorney to make gifts to himself. This language that you're referring to doesn't say that.
No, it says to those who, in my attorney's opinion, would be the donees I may choose. Would you acknowledge that the 4 children are the most likely recipients, and actually the 3 children involved here are even more likely than that?
Yes, but that, I respectfully suggest that's making an inference as to what that language means. And Gagnon was very specific in saying that the language had to be explicit and non-inferential with respect to self-dealing, dangerous authority to make self-dealing gifts. So I respectfully suggest that, as this court said in Rempalakis, when it's looking at the wording used by the Supreme Judicial Court, I don't think that language was casually used. It has to be explicit and non-inferential for a very important reason. So that language as to
I think, counsel, we're 2 minutes and 45 seconds over time. I think we'll have to leave it there,
Thank you very much.
and we will hear from your opponent, Attorney Bentley.
Good morning, Your Honors, and may it please the Court. My name is Tiffany Bentley, and together with Richard Novich, I'm here today on behalf of Christopher Baker, Anthony Baker, and Lisa Laporto. Your Honors, the power of attorney at issue in this case expressly authorized the decedent's sons to make gifts without restriction, restricted only by the parameters of fiduciary duty, consistent with the decedent's donative intent, specifically following the direction in the power of attorney that provided for gifts to be made outright to or for the benefit of such persons who, in the opinion of my said attorney, would be the donees I may choose.
So when you say unrestricted, you don't mean that literally, because it is restricted by the clause that says to those persons whom my attorneys, in their opinion, believe are the ones I would choose.
That's correct, Your Honor, that a judgment call would need to be made there that these were the donees the decedent would choose if she were in the position of making the gifts herself at the appropriate time under the circumstances that existed at that time.
Do you have any explanation for why paragraph 12 included express authority for the attorneys to become beneficiaries or remaindermen under any trust that was set up, whereas there is no comparable language in the gifting provision?
I can't speak to why that additional language was not expressly included in the gifting paragraph. What I do know about the power of attorney at issue is that it was the drafting attorney's standard form, and that on cross-examination at trial, the drafting attorney himself understood that the class of potential donees would include the decedent's children, would include Chris and Tony themselves. If that were the drafting attorney's understanding and construction of the gifting authority in this power of attorney, so too is it reasonable to conclude that it was Frances Fern's understanding as well.
So is it undisputed that the mother had no history of gifting beyond nominal amounts other than maybe setting aside $200,000 and then taking it back?
That's accurate, Your Honor, but it's also reflected on the record here that Mrs. Fern had received advice on multiple occasions from multiple different professional advisors about the size of her estate, about the potential future tax implications of her estate, and that those tax implications could be addressed in a number of ways. She acknowledged
So
that.
by reducing her estate by, I don't remember how many $1 million this is, like $6 million, did it end up being?
Approximately 5.5.
Right, so what's the tax savings from doing that?
The tax savings, and this was testified to at trial, I believe, by the drafting attorney, would be to remove those funds from the Massachusetts taxable estate. There is no Massachusetts state gift tax. There is a Massachusetts state estate tax. So the savings was in the amount of Massachusetts estate tax that was payable upon the decedent's death.
In the SJC's Barbetti decision about whether an agent can create trusts, there is a lot of discussion of the Uniform Power of Attorney Act as it's been adopted by other states, and the SJC kind of looks to that to figure out, well, what should be the prevailing rule. What does the Uniform Power of Attorney Act say about whether an authority to an agent to give gifts includes gifts to the agent itself, or whether there must be additional express authority? And I'm going to ask that question to both. I mean, your time is up, but if you know of, if either party knows what the Uniform Power of Attorney Act says about this, I think that would be helpful to us.
I don't know the answer, Your Honor. I would be happy to submit a supplemental writing after looking into that if it would be helpful to the court.
I think it would.
Happy to do that, Your Honor.
Is the 2013 will, or the final will, treating the 3 children equally, is that objective evidence of the donor's intent?
It may have been evidence of Mrs. Fern's intent as of April 2013 when she signed that will, but intent is fluid. And the history of this case, as was revealed over the course of an 8-day trial, is that there were many changes in circumstance over time with Mrs. Fern, going back to 2002, where she left almost the entirety of her estate to Chris and Tony to Tracy's exclusion, Forward to 2012, when she reversed that and left most of it to Tracy, to the near exclusion of Chris and Tony. Then to 2013, where she created the will that went to all 3 children equally. She did so based on circumstances at that time, which were that Tracy had reappeared after a significant absence in Mrs. Fern's life. That was something that brought her joy, and she was hopeful for the future, that the family would be reunited, that she would continue to share time with her only daughter and her only grandchildren. That did not come to pass. By the time the gifts at issue were made, when Chris and Tony were considering who were the donees that their mother would choose at that time, Tracy hadn't seen her mother for more than 3 years. Mrs. Fern was at the Regency. She was accessible. She was not being restricted. Her visitors were not restricted. She was not being secluded. Tracy could have maintained the relationship that she promised her mother she would. She didn't. And so it really defies credulity to believe that by the time these gifts were considered and made in 2016, that Tracy would have remained among the class of donees that Mrs. Fern would have chosen if she had capacity to make the decision herself at that time.
On page 43 of your brief, you make a statement that I couldn't find support for in the citations. And it says, the trial court also found that Frances had a historical pattern of gifting that favored Tony and Chris over Tracy and her children. And I wondered what that was. I mean, I saw a check, some birthday checks for $100, but to a lot of to Tracy and at least one daughter as well, so.
So it's a minor point, Your Honor, but it is supported in the record, and it's that in the history of making the birthday gifts and writing the birthday checks, Mrs. Fern traditionally sent $100 to Tracy, $100 to Tracy's daughters, but $500 gifts to Chris and Tony in the time period leading up to her, the 2012 incident in particular. So they were small gifts. She never made large gifts, with the exception of the $200,000 account that was discussed during the trial. But in those small birthday gifts, there was disparity.
Did the judge make a finding of fact about that?
I don't recall specifically. Your Honor.
Okay, thanks.
So he says that you're really looking at a limited view of Gagnon and that you have to go past the first holding. What do you say to that?
Your Honor, with respect to Gagnon, I take quite the opposite view. I think that my brother's reading of Gagnon is broader than what the case actually stands for. There are good sound bites in there about the sedulous application and uncompromising rigidity of the prohibition against unauthorized fiduciary self-dealing. But what Gagnon is doing in that section of the decision is not creating a new standard for the construction of the language within powers of attorney. It is speaking to whether a fiduciary's self-dealing transaction violates their fiduciary duty of loyalty, and those are two very different arguments here. The construction, the canons of construction applicable here were most recently summarized by the SJC in the Barbetti decision, citing to McQuaid, which has been good law on the books since 1955. With respect to powers of attorney, as with all written agreements, we construe the document to ascertain and effectuate the intent of the parties as manifested by the words used and the object to be accomplished. While powers of attorney are subject to a rule of strict construction, the rule does not go to the extent of destroying the purpose of the power. And that's precisely what would happen here if we were to read Chris and Tony out of the language in the gifting provision, allowing for gifts to the donees that the decedent would choose under the facts and circumstances at that time.
Well, it wouldn't actually destroy it. I mean, it still allow gifts to Tracy, to Frank, to Charity.
Sure.
Anybody except Tony and Chris.
Which would exclude the two individuals to whom Frances was the closest and to whom she entrusted with these types of decisions. That type of a result here seems unlikely to be what Mrs. Fern intended. She intended for Chris and Tony to be there with her. She intended for, the testimony at trial was that when it came time to do the gifting, she wanted to honor those who were with her at the end, those who were caring for her. That was Chris, that was Tony, that was Tony's partner, Lisa.
Your opponent is saying, though, that we should have some objective indication of that that's not just their testimony. What do you say to that?
I think that the Judge Donnelly's findings go beyond just crediting Chris and Tony's testimony. There is evidence in the record from Attorney Conathan, the original drafting attorney, talking about the reasons why, back in 2002, Tracy was excluded from the estate plan. There's testimony from Francis's dear friend Anna Weatherly about the relationships and how those relationships changed over time and how she saw Francis impacted by Tracy's lack of a relationship with her. About Tracy's lack of a relationship with her disabled brother as well. These were sources of pain for Francis. Francis had some optimism in the 2012 and 2013 timeframe when Tracy came back that things were going to be as she would have always hoped. But unfortunately, that's not what came to bear. And the evidence that came through at trial was really quite uncontested on that point. In fact, Judge Donnelly noted in his rationale that over the course of the 8-day trial, the stories that were told were largely consistent from party to party. There were very few very few contested facts here.
So you're pointing to a lot of other evidence that Francis might have ended up estranged from and had been at various periods of their lives estranged from Tracy. But what about evidence beyond what Tony and Chris say that she intended to give gifts to them? Is there any other testimony besides theirs?
There's not, with the exception of testimony from Attorney Conathan and Attorney Ward that they had discussed with Francis the benefit of doing some tax planning. Francis deferred on that advice. She did not reject it. And what she did by deferring on that advice was to establish documents that ensured that when the time came, if she couldn't make the decision herself to carry forth the tax planning, that the sons that she trusted would be able to do so for her, and that's exactly what they did, and the timing of the gifts supports that, having been made leading up to the 2016 presidential election when it was widely believed that Hillary Clinton would win the presidency, and there was concern among the estate planning bar that with a Democrat in office, the then existing estate tax exemption would be decreased. So there was a lot of planning done by a lot of folks leading up to that election. That's what spurred Chris and Tony to start talking about making the larger gifts to take advantage of the then existing exemption that may go away. And the gifts in total match up exactly to what that federal exemption was at the time. They don't add up to the purchase price of the Truro property. I suggest and have suggested throughout the litigation of this matter that the issue of the purchase of the Truro property is nothing but a red herring here. It doesn't matter what Chris and Tony
But
did
he
with
says that when you look at what they do with the money, that tells you whether there was ill intent or improper action. What do you say to that?
Maybe so, but what the court credited was Tony's testimony that it was not motivated, the gifting was not motivated by their desire to purchase the Truro property. It was motivated by a desire to ensure that effective tax planning could be done. And we have to give deference to the judge crediting that testimony. I do think that the testimony of Attorney Ward, the drafting attorney, was critical at trial here. Again, he confirmed that the language included in the power of attorney was the standard gifting power that he uses. He confirmed that his practice was to include that language if there may be tax issues involved with one of his clients, so that if there is an opportunity to make gifts, then we want to have that ability. Attorney Ward testified that his practice was to review every provision of his documents with the client, and he believes he did so.
Can you refresh me how she got connected to Attorney Ward?
Yes, Your Honor. This was incident to the 2012 hospitalization when
Who got her in touch with Attorney Ward?
Bill Henchy, I believe, is the one who made the introduction to Attorney Ward, and Bill Henchy, as a reminder, is the attorney who Tracy's husband had arranged for to meet with Frances during her hospitalization. Attorney Henchy came in one evening, hand-wrote some documents by which Frances purported to revoke her then-existing documents, and then subsequently it was Attorney Henchy who introduced Frances to Attorney Chris Ward, rather than contacting the attorney who had previously been Mrs. Fern's estate planning counsel, that being John Conathan of Nutter. I see that my time is running short. Unless your honors have further questions for me, I'll rest on my brief.
Thank you very much. The
Thank you,
case
Your
is
Honors.
submitted. We understand your positions. We're going to take a short break, probably about 15 minutes. Good morning. And just in case you weren't here earlier, we have 15 minutes per side with no rebuttal. I'm going to call the fourth case of today, November 17, 2025, which is 2025 P272, Department of Children and Families, and another versus Mother and another. And I believe we're hearing from Attorney Farmer first. Good morning.
Good morning, Your Honors. My name is Lois Farmer, and I represent Mother on this appeal as appellant. If it please the court. This is a termination of parental rights following a finding of unfitness of the mother. It's somewhat of an unusual story, I feel. When you look at a case that's dealing with unfitness, you have to look at the reasonable efforts, if they were reasonable efforts taken by the department. And in this situation, the department, met with the mother, gave her tasks or whatever, but I would suggest to you that was not sufficient. From the birth of the child, it was obvious to people around her, to the social worker in the hospital, to the response worker from department, that mother had some cognitive problems. There was a concern about some immaturity that she had, and nevertheless, they would mention that the mother was fitting, she was attentive to the child, she was acting appropriately to the child, and the hospital worker did not feel that mother would be unsafe with the child. But mother had a history with the department, as you saw. And so the question is, I guess, before the department now, are we going to have the same results as with the prior children? When the mother became pregnant, she essentially assigned herself tasks, similar to tasks that she would have had, likely had, when she was involved with the department before. She's engaged in sobriety. She went to Moms Do Care. She was going to the local medical clinic for MAT treatment, as you've seen. She was looking for housing, which on Cape Cod, if not anywhere else, is an extraordinarily difficult thing to find appropriate housing. She did all of these things. Initially, when she was pregnant, yes, she had taken some marijuana. She was told by the nurse, this is not good for your baby. She stopped. She had one slip after that. For the next 5 months until the birth of the child, she was sober. When the child was born, her exams were clean, the child's exams were clean. The child did have some reaction to the medication that was prescribed, but otherwise.
This is the Suboxone.
Suboxone.
Was there some evidence about injecting Suboxone and
At some-
instead of taking it buccally or sublingually, as I think?
I believe that the Suboxone had been prescribed to be taken orally, but she may have injected it. I don't know. It's not clear from the record exactly what happened there, when it happened. So, but initially, Duffy was not, the clinic was not concerned about it. So it was not a big issue, apparently. She would have been educated that, no, this is not what you do, and apparently it was fine. She was not overdosing at the time of the birth or for months beforehand.
Didn't the department offer the mother that she could, a 30-day letter that she could enter into a recovery program, and then the child could be placed with her there, and she refused?
She did. But please remember her history. Her prior children...
She has a long history of substance.
She has a long history in general, and she had been in a sober housing with 2 of her children. And as you may have heard in other cases, there's oftentimes drugs in these sober houses. And she became overwhelmed. She could not deal with her children and with the drugs that she was actually living with. And if you look at the housing test given to mother was to find stable sober, safe housing, and even with her prior children, that's not what she found. So she was a little bit, she didn't take this other housing. She's just not
But she
comfortable.
She
She
could
had
have had,
that-
right,
she
but she
had-
could have had the child placed with her, though, had she gone to this program, right?
They said that they would try to reunify her. There was no guarantee, but they would try to reunify her. No, she did not take advantage of that opportunity. But please remember, and this is what the SJC said in Rashida, that when there's a parental fitness and termination of parental rights cases, the court has to bear in mind that the parents are in trauma as a result of social services and court intervention. And we have a young woman who has a traumatic background that was explained in the neuropsychological evaluation. And she has multiple disabilities, cognitive disabilities, and we have to look at her as the individual and what would be appropriate for her. Now, the department had assigned tasks to mother, father, to the itself. They all had tasks. What you will not find in the tasks to the mother or to the department itself is anything pertaining to evaluation and proper treatment and handling of mothers' various disabilities, from cognitive issues, from inability to do math, to inability to understand,
So-
read, and remember.
Counsel, I should have said at the beginning, the case is impounded, and I really respect that you have abided by that by using mother and child, so that's great. Just want to, you've been great. But the mother's argument seems, or the department's argument seems to be that where mother wasn't maintaining her sobriety, and I want to be clear, you know, the mother should be commended for the efforts that she was making, no question about that. And I hope she continues on that path, no matter what happens here. But the department seems to be arguing, well, she really couldn't maintain her sobriety, there's nothing that's going to save this situation. That seems to be the thrust of at least one of their arguments. What do you say to that?
I would say that this is a complicated mother, but I think that this is a mother who has the ability to learn and grow, but not in the pace that we would expect it, and not without particular kind of assistance. Please look at the tasks that were recommended in the neuropsychologist's evaluation.
So there was not an organized effort to deal with her disability, it appears. There were some individuals, kind of ad hoc efforts by the social worker in terms of arranging transportation to visitation and things like that, and note-taking and slowing down and repeating things, but maybe not ideal. Is there reason to believe that if the department had done more to accommodate her various cognitive limitations, that it would have made a difference to her
Yes.
fitness?
And
why is that? And I'm focused particularly on visitation, sobriety, and housing. What would have happened differently?
As the trial judge had said, you know, when you're talking about sobriety, whatever, it's a process. And there, you know, sometimes there are slips. The mother did not slip in such a way that she was using daily for months and what have you. There's no indication of that whatsoever, only a couple of slips. But beyond that, once mother had, luckily had a new attorney, and we're not social workers, but nevertheless, we have a new attorney, and there seemed to be a turnaround there. And what happened was mother did start doing all the things, all the tasks, and in fact, the social worker, Nichols, went and testified that the tasks were done.
Right, so there was a turnaround a couple months before trial, and the judge acknowledged that and said, you know, it's not enough. My question is, and a big focus of your brief has been on the department's noncompliance, what you assert is noncompliance with its disability policy and not making reasonable accommodations for her disabilities. What is the reason to believe that if the department had done so, that she would have come before the court at trial with a different record on visitation or on sobriety or on housing.
I would suggest, Your Honor, that at the trial at that time, without the intervention, there was no hope. But had there been the intervention, and as recommended by the neurologist, neuropsychologist, they recommended having a parent partner, which was never offered to mother. They recommended that there be more support and oversight than others of the same age. You know, get vocational and educational training. The tasks of the department said, go get yourself a job. He says, get her some vocational educational training. So I would suggest that had the trial been postponed, now that the disability was disclosed just a couple of months before the trial by the department, that was far too late. But had the trial been continued for a year or so, allowed better, a more effective neuropsychology, neuroevaluations, had that social workers been afforded to mother that have a better understanding of what her needs are, that she would have developed into being able to consistently provide certainly the minimal care for this child. And that's the fitness standard. It's not better than pre-adoptive parents would give. It's, you know, just the minimal fitness is what's required, and I believe she could have done it.
The mother raised the ADA violation 10 days before a trial, right? So
The new attorney came in October, learned that there was a neuropsychological evaluation, and finally received the evaluation December. And the trial at that time was scheduled for December 18th. It wasn't going forward that time, so what they finally did, what they should have done at the very beginning, what they're obligated to do under their policy, is to investigate it. They do not have to wait until mother says, I have these disabilities and I need cognitive training or whatever. This woman has a 9th grade education. She has so many cognitive issues, but she's a lovely woman. They say it here in the case. She loves her child. She had great relationship, great visitations with her child every single time.
she had 7 visits, is that correct, in
Yes.
almost a 2-year period?
Initially, and then coming up until November, I think, or December was the final one, none since.
And how was that a result of her cognitive limitations?
I'm not a specialist, but if I look at it, I think that you look back at what this woman went through. They told her in the hospital, you know what, you're doing well. She thinks all she needs to do is get housing. She's already got her sobriety. You're doing so well. I don't see why you can't have your child. We expect you're going to be able to be with the child. And then they take the child.
So
She's not a person that can handle something. Anybody with her limitations would have difficulty handling those things without proper support. And she didn't have it. She's a woman alone, basically alone in the world. She needs the supports, and she needs it from people who know how to deal with it. The department didn't do anything to get her what she needed, and yet the department has done it for other people. So I would suggest, that she really and truly did the best that she could on her own. She got sober for her pregnancy. She was looking for housing. She went to moms who do care, so she had changed her approach from when she had the prior children. Then after this period of just not being able to deal with it, apparently she refocused. Everything was great. The social worker went to the housing. It's
we're
lovely.
running low on time, so I want to just shift gears for a moment. And if we set aside the finding that the mother misrepresented her status to obtain the 2-bedroom apartment, the department argues that would only amount to harmless error. What do you say to that?
Well, I don't think it's a harmless error because the judge looked at this as this shows that she lies all the time. She hasn't stopped lying. What can I believe? And what the credibility issue here is all important, especially for this woman who is trying to turn her life around and got the housing.
So along those lines, you contend in your brief that there were errors, findings of fact that the judge made, and that the judge referred to mother testifying as sources of, I think there were 4 places that you listed in your brief. I saw that, the judge makes the finding, and then she actually puts in parentheses where she got that information from the record. And it says mother's testimony, and I understand that mother did not testify in this case. However, if that information is found and those facts are found in other places, but not by, not because of mother's testifying, what is that?
What impact does that have on the decision? Is that the question?
Yeah, basically.
I mean, basically what it says is that I've shown you that the judge made a lot of errors with regard to the findings of fact, and this was one very obvious example of maybe how she was not quite getting things together. She had not read things well, and the problem is that she relied almost totally on the reports.
But those were admitted into evidence,
They were
correct? So they're
admitted
part
to
of the
evidence,
record.
but there's different evidence in the trial that she did not acknowledge, and it's important evidence.
So can I just ask, because I know you're out of time, other than those 4 instances that you noted in your brief that you say were errors because of the source of where that information came from, are you contending any other factual errors made by the judge?
I'm sorry, what?
Are there any other factual errors other than those 4 that you noted in your brief that came from?
There are, I'm sorry, I can't offhand remember everything that we have, but I know she quoted from General Laws 119, Section 21 report that said mother was actively using crack cocaine. There's no indication that mother was actively using crack cocaine. I mean, this is one of those things. You see it in other cases where they say this person wound up using cocaine for the next 3 months.
Okay, so
That's different than a slip.
All right.
Things like that I'm very concerned about. But I ask you to look at what mother accomplished.
Okay, I think we'll have to leave it there, and we'll hear from the department and the child. I'll remind everyone that the time is split 7.5 minutes and 7.5 minutes, and again, the case is impounded.
Good morning, Your Honor. Robert Fairbairn on behalf of the Department of Children and Families. May it please the Court. The trial court did not err when it found a mother with a decade-long history of polysubstance misuse that materially contributed to the termination of her rights to her 3 older children, who suffered from chronic housing instability until approximately 2 to 3 months before the termination trial, and maintained a relationship with the putative father that was characterized by substance misuse and domestic violence, and had visited her child only 7 times in the 685 days between the initiation of the care and protection proceedings and the trial date.
Can I ask you, how do you respond to the mother's argument about the department failing to show reasonable efforts in trying to accommodate the disabilities of the mother?
Your Honor, I would suggest the department's record in this matter absolutely demonstrates its reasonable efforts in this case. Mother's rights to her 3rd child were terminated approximately 9 months before the department offered a 30-day letter to reunify mother with the child. In reference to mother's disabilities, this mother has had consistent and regular contact with the department for the 5 preceding years. During that time, immediately after the removal, Your Honor, the department gave mother unlimited access to the child in the hospital, which she did not avail herself, including the ability to remain overnight. The department then offered a 30-day letter. The department then set up long 2-hour multi-visits to stage and to view mother's parenting assessment ability, and then use that as an ability to transition to maybe some other type of housing. The department went out of its way in every single opportunity to assist mother. They allowed mother to take notes. The social worker went so far as to secure beds in treatment facilities.
Can I just interrupt on 1 second? That phrase in the briefs struck me about they allowed the mother to take notes. Are are parents whose children may be taken away from them not usually allowed to take notes about what DCF is telling them?
No, Your Honor, I think that's language that the social worker testified to, or the way it came out. It's that parents are, the only thing we ask parents not to do is an agency is not record. Short of that, they can take notes. They oftentimes will have someone come with them, and in this instance.
So allowing the mother to take notes is not any extraordinary effort or anything out of the ordinary by DCF here?
No, Your Honor, but I think what it was.
Not an effort to accommodate her disability?
No, Your Honor, but I think it's an acknowledgement that if she needs additional help and assistance, that they're making sure that she does that. So the social worker also noted that she would repeat information. And I believe finding of fact 14 and conclusion of law 44 specifically note that at no point was there any indication the mother had an inability or demonstrated any evidence that she did not understand the information being relayed. But beyond that, Your Honor, if we look at the services department put in place, let's take
about her ability to act on the information, you know, some executive functions.
Your Honor, I don't think that was visible, but even if insofar if it were visible, I think the department's steps they took were different. Normally, the department can say, we want you to contact, a parent to contact IHR and set up an inpatient treatment facility. In this instance, the social worker would call on behalf of mother. The social worker tried to get mother to engage with the Living Solutions agency that was going to assist her with both housing and substance misuse to sort of deal with the two primary comorbidities that were impacting her parenting. When mother failed to get in contact with that provider from approximately October of 2022 until January 2023, the social worker still maintained that connection. After mother contacted that individual in January 2003 and nothing was coming, the social worker picked up the Solutions for Living's caseworker, drove her to mother's house for a meeting with mother and maternal grandmother for 5 hours and secured housing for mother in a sober living facility, which mother then subsequently rejected. I think what we see here, Your Honor, is the department did everything it could short of physically taking mother to a location against her will. We did everything we could to
But
assist
they
her.
argue the social worker was misinformed as to the ADA obligations of the department. What do you say to that?
I would say, Your Honor, there's three things. When the social worker was questioned, they asked if she knew what the ADA policy was, if she could recite it, and she could not. However, if you look at the social worker's actions in the context of the ADA policy, she complied with it. The ADA policy is outlined in our brief. I believe I quoted in full as amended in, I want to say, 2024. Notes that there are 3 steps that the department may take. One of the 3 is sufficient, and one is meeting with the supervisor and discussing what possible next steps would be. The social worker did testify that she would routinely meet with her supervisor, discuss the case, and try and develop a way to assist mother. I believe that's in transcript volume 2 between pages 71 and 76 is where that, I think, the relevant portion of the testimony is located. And in that, not only that, Your Honor, they did disability consults. Now, I think the timeline is a bit confusing because it's the testimony elicited was unclear. The court's findings are somewhat vague on that point. But we do know that a formal ADA meeting was convened in December of 2023. But the policy—
Just a couple months before trial. In fact, like 10 days before
10
trial
days
was
before
originally
trial.
scheduled. So I assume that the policy doesn't just say the social worker needs to meet with a supervisor, but I assume the supervisor has to do something with that.
They do. They have to adjust service plan tasks and trying to find ways to adjust, Your Honor. The policy itself doesn't require the ADA meeting, and when they did meet with the ADA consultant from the Department of Disability Consultant, they said you cannot hoist services onto a parent, sort of accommodations if the parent doesn't want them. And I think what we have here is the social worker was working with mother, trying to find any way she can to work with her. Mother was at all times represented by counsel. This was not brought before her. This was not raised. What specific accommodations were sought? But the department did, through their actions, you'll see, attempted to accommodate all the information we had on mother.
The mother argues that finding 13 was incorrect as a matter of law. What do you say to that?
Your Honor, I do not believe Friday 13 is as unfit as a matter of law. If you can give me one moment, I just want to refresh my recollection very quickly on that. I do not, Your Honor, I think the testimony in the record supports finding 13 quite clearly. I think the dispute tends to be on the formal convening of an ADA meeting, but the policy and the steps taken outlined in that were true, that the department did try multiple times to obtain a neuropsychological evaluation. And I believe the first written reference to that in the record is October of 2023. There's a note that the department had been attempting at that point to get an updated neuropsychological evaluation. Although the testimony unfortunately didn't nail down the exact time the department did it, we know it's probably somewhere between January and October of 2023. The department attempts to get an updated neuropsychological evaluation. However, the evaluator required 6 months of sobriety before that test could be deemed conductive, and mother's last self-reported substance misuse of ingestion of crack cocaine was May of 2023.
So I'm going to stop you on the substance misuse for a minute. I assume that you received the same trainings that we receive and that we're not using language like addiction anymore because it casts blame on people. And we've been schooled that we should use substance use disorder, that we should not refer to misuse because it casts blame and uses a lot of stigma language. So I was a little concerned that the department used that language throughout its briefs. I wanted to flag that for you because it'd be bad if one branch of the Commonwealth was getting different training.
That apology, that must lie with me, Your Honor, so I offer my apology.
But it just causes, I mean, whether it's here or at the trial level, it causes stress for us because we're not supposed to use that language. And then we have to then cast about in the record trying to find a basis and not repeat that language. I mean, that's what our instructions, all judges have been instructed that. So I'm flagging for you, you might not want to use that language.
Thank you, Your Honor.
Okay, we'll hear from the child.
May it please the panel, good afternoon. My name is Carrie Bagnall, and I represent the child in this matter. I'm going to go a little bit off script here and respond to Mother's argument. And on behalf of child, I'm in agreement that this is a process. It's a painful process to some parents. It can be a rewarding process to other parents. I have over 25 years of trial experience through the CAPE panel, mostly representing parents. I explain this process to them, and I offer encouragement to them regarding the legal standards that need to be met, and I encourage them not to feel out of control and helpless because essentially they are in the driver's seat. They're driving the bus. They have the ability to reunite with their children if they engage in the services required to address the underlying issues that gave rise to the child being removed. I would suggest in this case, Mother did not show up to the bus stop. Never mind get onto that bus and take control.
Well, but so just using, for example, Mother's inability to attend trial, if that was due to extreme anxiety, did the judge have an obligation to change the dynamic in the courtroom or allow her to appear remotely or do something to accommodate the medical situation?
I don't think there's a case on point with that regarding a judge in the middle of a trial or commencing a trial, but certainly here, the judge made it clear that she would do anything to accommodate the mother. Mother essentially left the courtroom in an ambulance and never returned. And it wasn't the first time Mother had failed to appear to certain important hearings. She never appeared for a foster care review and missed other court dates. Child's position, my position on behalf of child's 3.5 years of age today, is that Mother made no effort whatsoever to comply with the services needed to address very significant issues here. Housing instability, substance use disorder, domestic violence, those are 3 significant issues that have a profound impact on a child.
So the mother argues that she wasn't getting the appropriate services and that the department didn't make reasonable efforts to accommodate her disabilities. What do you say to that?
Mother argues that essentially on the eve of trial, when 8 weeks prior to trial, for whatever reasons, Mother starts re-engaging or I'm actually going to strike that, she starts engaging in services. She gets housing, she attends a 4-hour virtual Mommy and Me group. So it's incumbent upon the parent to tell the department what it is that they need. And while some parents might not know what they need, in that process, I'd argue with you, that process of communication, that's where the department and the department's experts can determine what the parent needs. But this court has made it quite clear in adoption of Daisy that the parent has to make that step first. Here we had a completely non-cooperative, non-compliant parent who refused to meet with the department in any meaningful way, refused to visit child for 6 months. Here is a mother that was essentially offered unfettered access to her newborn. Unfettered. Overnight visits while he was in the hospital. Unheard of. And she refused. There is no excuse, meaningful excuse given for her failure to do that. And failure to see her son for 6 months. Yet the department offered 2 3-hour visits. The department kept at mother to make these visits, and mother chose not to make those visits until October of 2022. She makes one in November of 2022. Next time she sees her son is June of 2023. That's 4 visits, essentially, in 16 months. The other 3 happen in succession on the eve of trial, while mom's in the process of doing the things she needs to do to get to address the issues, her shortcomings. On behalf of child, I'm going to suggest to this court that was a little bit too late. At what point do we say enough is enough? This court made that clear in adoption in Nancy. At what point do we say, okay, Mom, how long is this, we can't be on your train of progress. We have a child here. A child that has never lived with his mother, that, as I stated, is 3.5 years of age, who was born, substance addicted. He spent 26 days in the hospital undergoing 2 rounds, morphine rounds, for that addiction. He's never known mother. There's no bond between mother. At the time of trial, the court used the term regarding child thriving. And that's exactly what he was. Why was he thriving? Not because he had special needs that he's overcoming, because at that time, he was a child of 22 months and was receiving everything a child should expect. I'd argue not expect, it should be given. And that is what? A home free of chaos, violence, and filled with love. His pre-adoptive family is providing that to him, and he's still thriving. On behalf of the child, I am saying to this court, enough is enough. He's deserving of permanency. He's deserving of permanency with the current family he is in, and respectfully ask you to affirm the lower court's decision. Thank you.
Thank you very much. The case is submitted. Our next case is 2022 P163 in the matter of Manfred Gunther Kuzma, and the case is partially impounded. I would say to counsel, I think we'll have a lot of questions in this case, and we had, in fact, issued an order last week. So please keep that in mind as we hear from you, and we're hearing from Attorney O'Regan first.
Good morning, and may it please the court. My name is Robert O'Regan. I appear on behalf of Robert Tamkin in response to the court's order from Friday, we have
Time needs to start. There we go. Proceed.
in response to the order from November 14th, we have e-filed a motion to substitute Mr. Tamkin as personal representative of the estate of Manfred Kuzma. I call the court's attention to the decree entered on January 30th, 2025, resolving a will contest in favor of Mr. Tamkin and
So as a
appointing him.
housekeeping matter, what does that do with the brief that was filed by, I think, Attorney Spratt?
We're accepting that brief and ask the court to consider it on behalf of the estate. And in our reply brief, we indicated that the reply brief was filed in conjunction with both briefs that had been filed previously on behalf of Mr. Kuzma and Mr. Tamkin.
Okay, your pleading hasn't reached us, or at least me, yet. It does seem that at least some of your arguments are mooted by Mr. Kuzma's death. Do you agree with that?
The only possible issue that technically could be mooted would be the sua sponte removal of Mr. Tamkin as conservator, since the death terminates the conservatorship. But I would submit that nevertheless, that is an issue that the court should address and resolve, given the circumstances that this case presents that may well be existing throughout the Commonwealth, and the timing of the circumstances of Mr. Kuzma, and the timing of circumstances I believe we can all appreciate of people in significant health situations where there are issues presented, the authority of a healthcare proxy or someone purporting to act under a healthcare proxy to make decisions, and then a judge sua sponte removing a conservator under circumstances we allege were inappropriate for that to have occurred.
Well, so they argue that that's really an obligation of the probate and family court, that they can remove a conservator at any point sua sponte. So what do you say to that?
Well, the court has the authority to do it.
So shouldn't Mr. Tamkin have been aware that? I mean, in fact, actually at the pretrial hearing, the judge specifically says he understands these two people are in great conflict as to what should be happening here. And in fact, when I look at the pages that you cite on your brief about what will be tried, I don't see them, Judge, and if you want to point me to some very specific language, I would find it helpful, about what's going to be tried, because what the judge says is these two people are in great disagreement, and that's what the whole thing's about.
Your Honor, in the trial itself, and if I may, I'll submit the record references for the court. In the trial itself, repeatedly, the judge indicated the only issue before the court for the trial were Priscilla Merrigan's accountings as conservator. And he would repeatedly attempt to get the parties back to addressing the questions. When there was a presentation concerning what my client was alleged to have done or not done, that was taken in on the basis that it would affect bias or motive for the challenge to her accountings, not for the purpose of removing Mr. Tamkin as conservator.
So I understand that you're arguing that Merrigan should have moved him back to his home. And let's assume for the moment that we agree with you, although I'm definitely not saying that that is what's going to happen. I don't understand what harm to the estate there was, because it costs considerably less money to have him in assisted living. So what's your response to that?
That goes, Your Honor, frankly, to the fundamental question this presents. It's framed in the way Priscilla Merrigan responded to a question on moving him back, which was she perceived there was better value in having Mr. Kuzma remain in the facility than going home. Now, at the time she was making that assessment of better value, she didn't have the authority to make it, because there was no healthcare proxy in place that would give her authority.
They're relying not just on the healthcare proxy, but on the conservatorship appointment, that she was supposed to be making financial decisions, and there was a finding from the judge that he agreed to this placement.
There's also a report by a guardian ad litem, Karen Devine, that explicitly discussed with Mr. Kuzma whether he wanted to go home, and the answer was yes.
I know, but you overstate that report, which I find very troubling, because this report specifically says he wants to go home. I get that. Many elders do. But then it says when he has met certain goals, which she not indicate he had met, and the social worker said he could return home, quote, in a few months, and he continued to have these episodes. And she concludes he is currently in need of a level of care that requires him to remain in a nursing home. So when you take those statements and say that meant it was feasible for him to go home, I'm not really sure what you, that just seems like you are overstating.
It was feasible for a plan to be put in place for him to go home.
Okay, but we can't, okay, we don't have a magic wand. So even if we agreed with you, we can't move him because he has passed away. So what relief could we give you? That's why we're asking you what is or is not moot, because we cannot move him.
What is not moot are including, I submit that question, what is not moot is the question of attorney's fees and the attorney fee award. Much of the trial, if the issue, I'll rephrase it if I may, if the issue at trial were limited to and addressed the suitability of a decision and whether or not Mr. Kuzma was then capable of residing at home on objective criteria and ended there, that trial, scheduled for 2 days, I believe could have been less, but did not need to be 6. As you read the transcript, you will see what the trial turned into was a removal trial without notice to Fred Kuzma or to Robert Hampkin that that's what they were going to be trying.
So, but your client was represented during that trial, correct?
Yes.
And he attended that trial, all the
He did.
days of the trial? Okay, so he could see what was happening, right?
He could see what was happening, but he was not on notice that he was at risk of being removed.
Okay, but we can't change that because Mr. Kuzma has died. So when you say what's not moot is the attorney's fees, are you talking about trying to reverse the award of fees to Merrigan, or are you talking about adding an award of fees to Tampkin?
They're separate questions. So the allowance of the will is on appeal. The briefing on that,
At the moment, he has won that.
and at the moment, he has won that. And so with respect to his fees, whether they were awarded in that case, or whether that amount of money reaches him as a beneficiary of the estate, that is neutral to him. What is not neutral to him, in both circumstances, or to Fred Kuzma at the time, was the award of attorney's fees to Priscilla Merrigan. And this does...
Again, because I can assure you, we have plenty of work. So I don't want to do work that is not productive. So he's not worrying at this point in time, based on where the events have developed, about his attorney's fees. The issue is whether she should have received her attorney's fees.
Well, he cannot be out of concern that the judgment on the will stand. We're confident it will, but there are no guarantees. It isn't moot on the issue of attorney's fees awarded.
Attorney's fees?
Priscilla Merrigan's attorney's
Right,
fees.
I got that. But on his attorney's fees, is that issue, do we need to decide that issue?
I would say...
I was not actually clear you raised it in your papers, actually.
I would say that to manage the case, when the will contest reaches the court, the briefing should be done, I think, in 2 weeks on the current schedule, that if the will is upheld, his attorney's fees melts away because they get to him. If there's a further question about the will, they may not. I wanted to be able to tell the court that that issue goes away, but I cannot predict.
Did you raise that issue in your briefing before us?
The issue of attorney's fees.
His attorney's
His
fees.
attorney's fees was not raised in either of the, if I will, blue briefs. but they were, I would argue, subsumed in the way that the judge approached the attorney's fee issue, because the judge approached the attorney's fee issue in the entire case through the lens that Priscilla Merrigan exercised all of her judgments with authority to do so under an active healthcare proxy, which as a matter of law was not an active healthcare proxy. The record is clear, and there's no showing in any of the papers otherwise that the healthcare proxy designated Priscilla Merrigan was ever implemented as the statute requires that to
She says we don't have to
occur.
reach that issue because there was a finding that he consented to the move to Maplewood, and you didn't address that.
We addressed that by saying he consented to the move to Maplewood when he was being discharged from rehab facility as an upgrade. That doesn't mean he consented, and our position is that doesn't mean he consented to permanently residing in Maplewood.
Right, but I'm still back to what's the harm where we can't change where he lives, and it saved money. Mr. Tampkin has, if assuming he prevails, has more money in his pocket because of her decision. So where's the harm? What relief could we offer?
And this is where the judge's reliance erroneously on the healthcare proxy is important, because under authority of the healthcare proxy and the lens the judge used to look at the decisions, Priscilla Merrigan had the authority to keep him there, even though he may have reached a point where he didn't need to stay there. And the issue,
Is there any evidence that he didn't need to stay there? Because that guardian ad litem report says he needed to be there.
in the trial, the issue was not whether then he needed to stay in the nursing home. The trial issue was whether the accountings of the conservator were appropriate. And the lens that the judge viewed the decisions to keep him there was on the impermissible conclusions and deference that under the healthcare proxy, Priscilla Merrigan had the ability to keep him in a facility where he did not want to stay.
Right, but again, but she was removed. And at that point, if he was movable, he could have been moved. But nobody moved him ever until he died, right?
He was not able to be moved.
So again, what relief? I really want your input, because once you're done, once you sit down, we are left to wander on our own, and I'm not getting any input from you as to what relief we could offer on this point. We can't move him. We cannot go back in
Can I ask you a
time.
specific question about whether you are seeking certain relief? It seems like you're arguing that she breached her fiduciary duty as the conservator, and that she didn't have authority to make certain decisions under the healthcare proxy.
Yes.
So as a result of that, are you saying that the judge abused his discretion by awarding her all of her fees, and that he should have awarded her less?
Our position, he shouldn't have
That's the
awarded
relief
her.
that you're looking for from us now.
He should not have awarded her any fees, and as stated in the affidavits of objection, he should have looked at the cost of maintaining Mr. Kuzma in a facility where he did not want to be, and determine whether and how much of those fees were appropriate and how much, and whether they weren't, and the amount.
Fees paid to the facility?
To the
or-
facility.
And what would the remedy be? That they would be recovered from her, to the extent they were excessive, they would be recovered from her individually?
They could potentially be recovered as a surcharge on her accounting.
Well, I didn't see that raised below.
I believe it was raised
There was
in the
some
proposed.
disagreement about the attorney's fees, but
I believe it was raised in the proposed findings and the affidavits of objections that Mr. Kuzma should not have been kept in Maplewood as long as he was, and therefore the cost of the residency, not the cost of what he ate in the medicine, but the cost of residency where he had a residence, would be appropriate to look to the conservator as an inappropriate charge on her accounting.
Even if that costs less than moving him back to his home?
I'm sorry?
Even if that costs less money than moving him back to his home?
There's no question Priscilla Merrigan agreed he had plenty of money to do whatever he needed to do. If Fred Kuzma decided, and this is in the record, he loved his house, he loved his garden, if he could be happy at home with
I know,
any
but you're
support he
saying she
wanted.
spent money inappropriately, and we can't move him. I'm going to say that again. I won't say it again. So let's say, just to make this easy, that it costs $10,000 a month to keep him in Maplewood, and it would have cost $22,000 a month to move him back to his home. We cannot make him happy by moving him back to his home. I did say it again. So why would she pay the $10,000 when it would have cost the estate $22,000?
Because even under the conservatorship statute, the conservator is to give due deference to the protected person to handle his or her own affairs. If Fred Kuzma thought his life would be better and he was willing to spend the money, because what he needed help for was the physical management of his assets. His mind was working. He had a number of cognitive deficits related to communication. If he was willing to spend the money, it was not within Priscilla Merrigan's authority under a non-existent healthcare proxy to not let him go. And the fact that to her, the value, I'll use Your Honor's number, was $11,000 less if he kept in the nursing home. His value was, I want to go home, I want to be in my garden, I want to be in my neighborhood, I want to be happy. All of us should anticipate that individuals in Fred Kuzma's circumstance understand their circumstance.
And you're seeking to recover a surcharge from her essentially as damages for emotional distress?
It's a decision that she made that she did not have the authority to make against the wishes, and we're not wishing to punish anybody here. And it may well be that when this goes back down, the court makes a decision that the expenditure was something that should not have made, but assessing a surcharge is still discretionary by the probate judge. And so the probate judge may decide to surcharge less than all, a portion, or none. I don't predict.
The claim could have been raised even while he was alive, correct? The claim that whatever was being,
I believe that is in the affidavits of objection. I see my time is up.
What is the significance of the medical certificate, guardianship, or conservatorship that Dr. Murcia completed on March 14, 2018?
That was right after Mr. Kuzma had been returned to the United States. The evidence in the record, I have to confess, is unclear whether that was the result of a stroke, it's described as a stroke, or an epileptic seizure. So 2018.
I don't care about what the medical cause was. He's completed this certificate, and you're saying there wasn't enough done to invoke the healthcare proxy. Why is this certificate not enough?
Because the statute, General Laws, Chapter 201D, Section 6, has specific requirements which include an attending physician in the medical chart indicating that the healthcare proxy is activated, and a description as to why, and the healthcare proxy must become a permanent record of the medical record. None of those steps were taken.
Are you saying that Murcia was not the right physician?
I'm saying that the medical certificate does not satisfy the requirements of Chapter 201D, Section 6.
It's not enough to say that he can't remember information from one moment to the next, and he has severe memory deficits, and he could not pay a bill or not recall later if it had been paid, and that he's very vulnerable to being taken advantage of, that those statements in there are not enough.
The statute is clear that the doctor must invoke the healthcare proxy, state that the healthcare proxy is being invoked, and the healthcare proxy must be part of the permanent medical record for the healthcare proxy to become operative. None of those things were operative. And if Your Honor follows the medical record, and this is in the supplemental, this is in Volume 7 of the impounded appendix, you will see that his status improved over time, and that two neurology or neuropsychiatric evaluations done in 2019, even the description of Karen Devine, when she met him in December 2019, in her guardian ad litem report, indicate an individual not described by the person in that medical certificate.
One quick question. You referred to the surcharge having been sought in the proposed findings by, I think, your client, Mr. Tamkin. I don't see that in the record appendix. Is it there?
The proposed findings are, if I may, I'll supplement. I believe they're there.
The Priscilla Merrigan's, but not yours.
Ours are there. I loathe to hear this or speak it, but I was not trial counsel, and I regret as a consequence for that. I'm not as intimately familiar with the trial record as we are when we try cases, but I will, if I may, supplement with record references for that, and if I turn out to be mistaken on that, submit an apology for getting it wrong.
All right, we'll hear from
Thank you, Your
Attorney
Honor.
Gillis.
Thank you.
Good afternoon, panel. My name is Michael Gillis. I represent Ms. Merrigan. There are 4 issues. The first I think I can get through. First, Mr. Tamkin's entire appeal brief talks about the fact that just because the finder of fact did not find the way he would like them to find, that it should be overturned, and that's certainly not the standard. There was no abuse of discretion here. Judge Riley wrote 174 paragraphs of facts which support his opinion here. When testimony was conflicted, he rightfully decided
Well,
where
what
the
about, he's basically saying while he was ambushed, he didn't know that whether he should be removed was on the table.
I didn't know it was on the table either. It wasn't discussed. It didn't come up. It wasn't an issue at trial. It was done because the judge was so horrified by his behavior that he sua sponte removed him. All you have to do is look at the 174 paragraphs, and then
Did the judge
if
need
you
to
look
give
at the...
him notice that he was thinking about doing that?
No. It was done after the fact, after everybody did closing arguments. If you look at the reasoning, he put 5 bullet points there. And if you read those 5 bullet points, basically what he says was this gentleman preyed on a physically, mentally, and emotionally handicapped person for his own personal gain. He had aphasia, he had multiple strokes, he had memory loss, he had dementia, he had pulmonary embolisms, he had OCD, he had emotional distress, and he went down and basically decided to make his way through sexually to him to get his neighbor, Ms. Gregg, drive to the Cape and for $10,000 say he was competent to make Mr. Tamkin the conservator in the first place. And then the same doctor went down again to say he was competent to write a will that his other neighbor, Ms. Strausskin, drew up for him. Not Mr. Kuzma's attorney, but a different attorney. And on top of that, Mr. Tamkin testified that he had talked to the neurologist to see if he was capable of having physical sex with Mr. Kuzma, and he didn't use that same neurologist to say he was competent. He took a neighbor of his who drove down with him, was not an MD, to do that. So those were the reasons, unbeknownst to anybody here. This trial was not about that. I agree. But if you look at the Norfolk District Attorney case that cited that, attorney of Norfolk County versus McGraw.
Judge had the legal authority to do this, right?
And the obligation, I would say, given these circumstances, the facts in this case were so overwhelming.
Can you respond to his argument about the healthcare proxy not being invoked?
I think if you were to follow the letter of the law and dot all the I's and cross all the T's, that I think that may be correct. But it was clearly that was the manner in which everybody was operating throughout this, starting with Mr. Tamkin.
He called, right, and asked your
Called her
client
and asked her to invoke it to get the medical records to send over to Germany in the first place. And from that point on, but I don't think we even get to that issue because, as you point out, the findings of fact, not what was portrayed to you by counsel, but the findings of fact by Judge Riley say that she did everything that was well within her broad discretion as the conservator to do what was right for him. Yes, he wanted to go back to Wellesley. Everybody wanted him to go back to Wellesley. But as was confirmed with Mr. Tamkin, he was a very private person and didn't want 24-hour care in the house. And that's why he didn't go back. Everybody agreed that he was unable physically to be there by himself. It was agreed that he couldn't take his medications by himself. The problem with this whole thing was that Mr. Kuzma wanted to be there, but was unwilling to do the things that he could do to go back there, and it wasn't prudent. As Mr. Tampkin testified, he saw a contract that could have been up to $200,000 to retrofit the house. It was going to be $24,000 a month to have services went in when the base.
But it was his money. He could spend it that way.
But where we're going off track here, Your Honor, is that there's no evidence whatsoever that he said that he didn't like where he was. He said, if you look at Ms. Braun, she said in the 2 years that she was there with him, he never once said, I would rather be in Wellesley than here.
Well, but we have this guardian ad litem report who says he wants to go home.
If he's able to, but he's not, because the conditions of going home require him to have 24-hour care, which he is not willing to have in the house. That's what the finding of facts were.
So you started your presentation by saying there were 4 issues. The first was that there was no abuse of discretion. I want to make sure we know what your other 3 issues were.
I think the second issue we talked about was the healthcare proxy, which you've talked about at length. She did everything that she had the right to do as conservator. That is a red herring. And I think for all intents and purposes, everybody operated under the fact that it was invoked. And lastly, that was not an issue that was discussed at all during the trial. That was an issue that was brought up, my memory, at the very end as part of the oral arguments afterwards. This whole case, as was said by counsel, was about the accounting. And it wasn't about the accounting to the extent that the dollars and cents made coincided. They stipulated that the bills and the payments equaled up. The only issue was they said that it was inappropriate for him to be in that facility, which you pointed out, 5. There were 5 conservators. There was Ms. Merrigan, then Mr. Tampkin, Mr. Crook, and then when he was removed, Ms. Long, and when she could no longer serve, Mr. Beerhans. All 5 kept him exactly where he was because he was thriving there. The testimony of Ms. Braun was that he was there for every event, particularly if he could get a glass of wine at the event. He was there for every event that had music. And all 5 of them left there. The difference between Ms. Merrigan and the rest is that she was the only one who put him in that facility in an independent housing, which would not require some sort of medical views. The rest of them had him in a rehabilitation or assisted living. So as far as that issue is concerned, and she was found by the finder of fact that her broad discretion was properly invoked under her conservatorship.
So are you saying that she did not make any medical decisions that would have required the healthcare proxy to have been activated?
I don't know of any medical decisions that she did make. I think all the decisions were made by Mr. Kuzma, and Mr. Kuzma had falls inside so when he had falls, the facility itself brought him to the hospital. I don't think that was her decision. He was returned to his independent living. The fact finder found that she went and brought him 8 different places before he was situated at Maplewood.
The GAL says, as you just paraphrased it, he wanted to go home if he could.
If he could.
Who determined that he couldn't?
I don't think that decision was ever made because he was comfortable where he was. One of the things.
But when she was conservator, when Priscilla Merrigan was conservator, did she decide that he couldn't go home, and wasn't that a medical rather than a financial decision?
I think it's both. I think that for him to go home, he required 24-hour care at a cost of $24,000 a month and $200,000 worth of retrofit, and he wasn't willing to have anybody live in the house with him. So it's one thing to say, I want to go home. It's another thing when you say, I want to go home, but I'm not going to agree with any of the conditions that are required of me to get home. And as Mr. Tampkin testified, his condition over time continued to go down slightly. So he was never in a better position that he could take care of himself. This is a gentleman who could not remember his birthday, but had multiple anti-seizure medications that he would require to be taken several times a day, which he clearly could not do if he didn't have 24-hour care.
Right, and the facility put him on 1-hour checks.
Right.
So was Attorney Craig Spratt a neutral?
Was Mr. Spratt a neutral?
Yeah.
He was appointed to.
But he didn't have ties to anybody, did he?
I don't know of any ties to any party. All I know is that, he put in a fee of $89,000 in this case to go along. He did not try the case. He did not participate in the case. He just went along with Mr. Tamkin when he opposed this, and he went along with Mr. Tamkin when he filed this brief, but at no time did he participate in the trial itself.
What about the GAL, Cynthia Borget? Does she have ties to anybody?
I'm not aware of, I was not involved with the case at that point. I only knew of Mr. Glazer, Attorney Glazer, who testified at trial. I did the trial portion of the case.
You say in your brief that the judge found that the move to Maplewood was with Mr. Kuzma's consent. I didn't see an express finding to that effect, but can you point us to where the judge comes closest to saying that?
I think it's twofold. I think it's the testimony of Attorney Braun, Nurse Braun, who worked at the facility.
I'm not asking for the basis so much. I'm asking for what the judge said in his findings.
He said that...
What comes closest to saying Mr. Kuzma consented to go to Maplewood?
The findings of fact say that Mr. Kuzma looked at properties with Ms. Merrigan. There were 8 in total, 3 of which he physically went to. The findings of fact said that an application he put in for Victoria was accepted, and that's where he wanted to go, but he
I'm going to just cut you off because we have a lot of other questions, and it's on page 22 of 24, which is also the blue brief, page 85. In the last line, it says, with his consent. It's an express finding. So you said 4 issues. I've only heard 2.
The third issue I think you already talked about, and that was the sua sponte, removing him for that reason. I don't think we have to go over that anymore for the simple reason that I believe that it is a moot issue, but I believe that the judge had ample evidence to remove him because, as the statute says, if there are any conflicts of interest, and there was a clear conflict of interest here because the first thing Mr. Tamkin did when he became a conservative was to pay him back the $18,000 of which was the initial rub between Ms. Merrigan and him. This charging a friend for a few phone calls to get him back from Germany, $18,000 as a friend, not something that was ever considered before. He said he would help A, B, charge him at $300 an hour when his billing was $200 an hour. That, in addition to the other things, were reasons why the judge had every right to remove him. Lastly,
he says, though, that there was, that Dr. Horgan specifically opined that Kuzma had the capacity to engage in a sexual relationship. Do you agree with that?
I don't. There is no medical record that says that. It's only the broad testimony, self-serving of Mr. Tamkin at trial, but there's no evidence of that in any medical record.
The medical record says that he had the capacity to make decisions on his own, but it doesn't, it specifically at one point says he can make specific decisions, but he doesn't say what those decisions are. So
I agree.
I don't know what to make of that.
I think most of what the fact finder found was this was a gentleman who was very prone to being unduly influenced, particularly in that nature, and that's exactly what happened. There was a battle at this case prior to my involvement between Ms. Tamkin and Ms. Merrigan simply because she said, I don't have a problem stepping down, but I believe that he's going to prey on him and that he shouldn't be the conservator. That was the fight all along. She eventually dropped that prior to trial, which is when Judge Riley said the sentence should have ended, but he pursued it, and you can see why. He pursued it because no other independent person would allow him to make himself personal representative and beneficiary of a $4 million estate. No other person would allow him to bring down a non-involved, non-MD neighbor to make a decision on whether or not he wants him as a conservator and whether or not he's capable of being attorney. No other non-involved person would have their lawyer write the will instead of Mr. Kuzma's own lawyer. So there was a lot of reason for that.
All right, did we get to your 4th issue? Because I have that your 3rd issue is that sua sponte removal was okay.
The 4th is the attorney's fees, Your Honor. The judge awards fees pursuant to Section 45 of the statute, presumed to be right, and will not be disturbed unless there's an abuse of discretion. Not to be lost in the court that the prevailing party was awarded fewer fees than the non-prevailing party, and the non-prevailing party billed Mr. Kuzma more than double what was paid out to the prevailing party. There is nothing in the brief or anywhere else that says, it seems very disingenuous for the non-prevailing party who was found to have brought a meritless case seeking $400,000 in legal fees to say that an award for the prevailing party of less than half of that
Do you
is an
think
abuse of
any
discretion.
issues are moot for us that we don't need to decide them?
I would say that whether or not the sua sponte was be moot, I think he had every right to do it, but now that Mr. Kuzma has passed, I don't see the relevance of that.
Anything else?
No, Your Honor, just that the attorney's fees were reasonable, and they were what they were simply because, as the judge found himself, Mr. Tamkin refused to walk away at that point, and the case shouldn't have gone on, and he was the one who cost Mr. Kuzma additional funds because of his failure and his unreasonableness in resolving the matter prior to trial. I rest on my brief for the remainder, if there are no other questions.
Thank you very much. The case is submitted. We understand your positions.
Thank you, Your Honor. I appreciate your time. Thank you.
With that, we'll call the last case of the day, which is 2024 P1396, Matthew Walston and another versus North 12 LLC and others. I think we're hearing from Attorney Moriarty first.
Good afternoon. May it please the Court, Thomas Moriarty for North 12 LLC. I will address 3 points before the Court this afternoon. First, the trial court's decision finding the adverse possession of North Street to the east of the existing fence should be reversed because the plaintiffs did not satisfy the elements of
I'm
adverse.
just going to say, just for myself, that referring to this as A, B, and C is helpful, but you can refer to things however you want.
So the reason that A, B, and C doesn't work for this argument is because it's split a portion of C, we would argue, to the east of the existing fence. The plaintiff did not prove adverse possession with regard to. We are not advancing any claim relative to the court's finding to the west of where the existing fence is. So that's the one division we have to make with regard to Area C.
That's helpful.
The second point, the trial court erred in declaring that the plaintiff owns a 25 by 12 and a half
Can we
foot.
just pause for a minute, because I don't think you've been speaking for 6 minutes. So I don't,
Oh, we're sharing.
You're sharing.
Yes.
Thank you. I'm sorry.
Yes,
Go
thank you,
ahead.
Your Honor.
Yep, go ahead.
Thank you, Your Honor. The trial court declared that a 12 and a half by 25 foot area to the south of Middle Street was owned by the Walstons pursuant to the derelict fee statute, and we would argue that was in error for 2 reasons. First, no party asserted that claim in the case, and second, because the law applied pursuant to the derelict fee statute would not allow it. And finally, any easements benefiting the plaintiff's property have either been substituted, relocated, abandoned, or extinguished. As regards the first point, that the trial court's decision establishing adverse possession to that section of North Street to the east of the existing fence, there was no evidence of continuing use. And we readily concede continuous does not mean constant, but acts of few and intermittent and equivocal control are insufficient.
Can I just get a factual question straight about how the judge decided where the line between areas B and C was? Did he place it as C, the eastern edge of C was the extent of the use made by Stephanie Teller, or Stephanie Bell, and her husband, her former husband, with the parking of the RV and other uses?
That is unclear, Your Honor. What the court indicates in its judgment is that at some time between 1984 and 2019, certain uses were made. So that would include or encompass the time where Teller and Bell owned, and also during the time that Walston owned. There was no specific use during any particular 20-year period that the court pointed to.
I'm just trying to get straight, though, how he drew that line. Whether it was the right line or not is a separate question. But in trial finding 13, he says the point where Teller and Bell's parking ended is the boundary between areas C and B. Now, we can argue about whether the parking was intermittent or continuous or, met the criteria for adverse possession. But do you agree that that's where the boundary is?
As established by the court, yes. That's what the court seems to have determined.
Okay. And do you agree that however frequent the parking of the big RV was, that the rear of the RV fell roughly on the line between B and C? No.
No, Your Honor.
You don't?
No. The testimony reflects that the only percipient witnesses with regard to that use that testified was Ms. Teller. And she...
I know about the extension cord and it was parked close to the house, but we can see in many aerial photographs that it was parked beyond the driveway.
Oh, absolutely.
Right. Okay, so is the back of that RV, is that where the judge set the boundary between Area B and Area C?
In our opinion, no, Your Honor, and that's just based on the record. So what the record reflects is testimony from Ms. Teller that that RV was parked in an area that was essentially in the space to the west of the existing fence.
Okay, but we can see it parked somewhere else.
Yes, but what you see in that aerial does not put that RV beyond the existing fence. So there's
Wait,
no...
when you say existing fence, I'm sorry.
So there's a fence that's depicted in...
You mean the fence that your clients built?
Yes, our predecessor put up.
Oh, okay.
So there's a fence that essentially transects Area C on North Street. So to answer the court's question, the trial court puts the RV several feet beyond, let's say 10 or 12 feet beyond the existing fence. The defendant's position is that the evidence shows that that RV was never parked beyond the existing fence. So those photographs, those aerials you look at, one can do their best to try to position where that RV was, which was, by the way, Your Honor, only owned by the Tellers for 7 years. But there's nothing that explains in any greater detail where that RV was relative to the fence, other than the testimony of Ms. Teller. So what...
Well, the judge says in finding 13, their use of the disputed way for parking, which I think means however frequent the parking of the RV was, ended approximately 55 feet west of the eastern edge of MS Way. So...
There is nothing in the record that justifies that numerical calculation, Your Honor.
And do you have any idea how the judge decided on that figure?
No, Your Honor.
Like, did he, make a scale using the 2020 plan and figure out?
It is unknown to my client how the judge came up with that numeric.
And what about how did your client decide where to put the fence, or your predecessor?
So the predecessor testified that he cut that fence onto North Street at the end of where the overgrowth was at the time.
So on the 19 north side of the overgrowth.
So it would be where the overgrowth was within the 25-foot right-of-way that we're referring to as North Street. So what Mr. Hegarty, who was the predecessor owner, or principal of a predecessor owner, testified was that when he put that fence in May of 2019, he removed substantial shrub and overgrowth from the way, and where he stopped and cut the fence basically perpendicular to North Street was in the area roughly where the lawn area had been installed by the Walstons and the scrub continued to exist.
And so was the judge bound to accept that testimony?
Oh, the judge is free to accept or reject any testimony. The question is, did the plaintiff prove that any use was made beyond the point of the fence as it exists today? The only testimony from a percipient witness, as I said, is from Ms. Teller, who said it was to the west, that RV was to the west of where the existing fence is on Exhibit 20. But there's no testimony at all that there was any use.
Where did she say that it's to the west of the existing fence?
So she makes reference to.
She must have been just looking at photographs because she didn't go back at the time that Mr. Haggerty put in the fence.
No, she was looking at a plan that was marked as Exhibit 20, and it is attached in the appendix to Volume 6 on page 94. So what she did during her testimony is said, this is where the RV was. But if you look at the aerial photographs, even if you accept that the RV was beyond where Ms. Teller says it was, they only owned the RV for 7 years. There's no other photograph that puts any vehicle as far as the edge of that RV. So even if you accept the location as true, that is, the RV actually went beyond the fence, which Ms. Teller refutes, there is no evidence that that use was consistent for any particular period of 20 years.
Do you have a citation to where she said that, looking at, I guess, Trial Exhibit 20? Well, if you don't have it handy, we'll...
I do, Your Honor, but it might take me a moment. That is, I can't find it here, Your Honor. Oh, yes, that would be, looks like in, no, I really can't find it here, Your Honor. I can say that we cited it in the brief. So we have a pinpoint cite to that in the brief. And I know my time has expired.
But I think we might have some questions here
Yeah.
still. So we'll make sure everything's fair.
We're going to keep going a little bit.
Yeah.
On the the summary judgment on the extinguishment of by prescription of the easement over the eastern section, it seems to come down essentially to the testimony that Mr. Carroll put shrubs across North Street.
On the extinguishment argument, Your
Yes.
Honor? Yes.
Yes.
It's shrubs and rocks, I think, was the testimony.
Shrubs and stuff, I think was what I read. So the very next paragraph of his, or the next answer in his deposition is, yeah, I don't know. He might have. I really don't know because I never went out there, you know? So, I mean, he's basically disclaiming that he has personal knowledge of what was put there or by who. Is that the stuff of summary judgment?
So what he said in that instance was that he had never been out there, but the record shows at the time that that way had been cleared, so there's no suggestion that it wasn't observable, meaning that it wasn't overgrown at the time. That had been a cleared way. It had grown over thereafter, after Mr. Carroll put
Okay, but how do we
those-
know that it was Mr. Carroll who planted shrubs there rather than just natural growth of vegetation?
Well, other than the testimony of Mr. Teller, I don't believe there is
Okay,
evidence.
so then what adverse act is there by Mr. Carroll or his successors that could extinguish the easement over the eastern section by prescription?
Well, I will say that that was a subject matter that Mr. Goldsmith was going to address, how we split the time. My focus was going to be on the fact that extinguishment is irrelevant because it was clearly either substituted, relocated, or abandoned.
Okay. Can I ask a question about abandonment?
Of course, Your Honor.
The Benvenuto versus 204 Hanover case says that there has to be some affirmative conduct that's inconsistent with the exercise of the easement. And I'm wondering what that was here.
So that's in connection with non-use, Your Honor. So we would immediately concede that non-use is not enough. If there is simply non-use, you could not demonstrate abandonment.
It's not just non-use, it's failure to protest. There's some case law cited in Carlson v. Fontenelle that says failure to protest could give rise to an inference of abandonment. But the Benvenuto case says, but that's not enough. There's got to be some affirmative act.
Right, if you're relying on that, Your Honor. But the case law says that what you're really trying to assess here is what the intent of the party possessed of the easement intended, right? What their position was relative to the easement. So if you're going to rely on something that is, let's say, coincidental or that is empirical, you can't just rely on non-use. You have to show an affirmative act. In this instance, Mr. Carroll testified, that Mr. Teller testified that he intended to surrender the easement. He specifically said that at trial. It was my intention, by no longer using that right-of-way, to surrender its use. And there are also other factors. The fact that contemporaneously, from that point forward, Mr. Teller never used North Street, that he, in fact, used another right-of-way for an extended period of time.
Do you have to say that he abandoned it or surrendered it or gave it up at the time?
No, Your Honor. There's nothing that suggests that you have to infer intent if there is other evidence, an affirmative admission, a statement by the party possessed of the easement that says, not that I no longer intend to use this.
Right, but he made that statement in his deposition and at trial.
Right.
Did he have to go out, Mr. Teller, at the time that South Street was opened up and maybe stand at the boundary and say,
He did not.
hereby announce?
He
So
did
then
not, Your
how
Honor.
can anyone know?
Because there were
There's no act by Mr. Carroll.
Oh, there were, yes. There certainly was an act by Mr. Teller. Acquiescence in and of itself can constitute an affirmative act, but there were other affirmative acts.
What case says acquiescence is an affirmative act?
Your Honor, I don't have the cite, but it would be the line of cases that we've cited. We have cited them in the brief. Give me one moment.
Well, we've read the brief and we'll read it several
Yes.
times more.
But, Your Honor, the fact is there were other affirmative acts as well. It wasn't just acquiescence. The case law suggests that parties can demonstrate their intention to abandon easement A or relocate, in this case, because they would be basically the same act. You're abandoning the easement to go over North Street to Peases Point Way, but you're relocating that easement so you're not rendering yourself landlocked.
Well,
what they did...
Did Mr. Carroll relocate the easement?
Oh, Mr. Carroll built South Street.
But did he give the owners of the Lot 1 any right to use South Street?
So that would be the substitution argument.
Right.
So the substitution argument, weaker than the abandonment and or relocation argument. So the substitution argument, there was no recorded deed after that.
And what he has to substitute is a right of way.
Right.
And he might have created a way which they could use, but that was adverse to the abutters on South Street. He would have to get away with it essentially for 20 years before he had any right. So I don't see how Mr. Carroll substituted a right of way for North Street.
So at the time when Mr. Carroll owned the property, it was open to use by the tellers, and the tellers had a deed which was then satisfied by performance. There are all sorts of instances.
Well, I'm not seeing how Mr. Carroll gave them a right, an alternative right of way.
So
He gave them a sort of an inchoate right that maybe if they used for 20 years without protest might ripen into a right.
Are you saying Carroll retained property sufficient to allow him to?
He owned South Street. So when he built South Street, he had the ownership interest of South Street. He had the absolute right to allow Teller to use that way. But
He didn't save that. I mean, when he sold the lots abutting South Street.
Right, but there is a deed.
He didn't hang on to any right to use it for anyone but himself and his heirs and assigns.
With regard to the substitution, Your Honor, there was already a deed on record. Anyone who bought was on notice, right, that with regard to North Street that continues on to South Street, Carroll's, and it was all in Carroll's title, that Carroll could perform an obligation pursuant to that deed. There are all sorts of instances in the law where a circumstance may require a writing, conveyance of real property, for instance, where partial performance is sufficient. Here we would say there is a recorded deed, and that deed puts anyone on notice that there's a condition that could be satisfied and the condition was satisfied. Now, I said in answering your question, Justice Sachs, it's the weaker of the arguments. The stronger of the argument is that the relocation can happen even tacitly. It can be implicit. The law is clear, the case law is clear, that a relocation, if two parties agree that the use is going to be allowed, not in the location where the deed indicates, but in another location, and the parties for a period of years follow through with that use, that is sufficient to constitute a relocation. So at a minimum, we have a relocation in this instance. All of the conditions to support relocation are evidenced by what the parties did, as I've already articulated.
One question about Area A. If we vacated the declaration of ownership of Area A, as you're asking us to do we need to remand for the judge to resolve the issues that he said were mooted by his declaration of ownership?
No, Your Honor, because the parties agreed in a stipulation that when the 12 North was conveyed by Mr. Carroll to not our immediate predecessor, but an earlier predecessor, that the entire 25-foot width of 12 North Street was conveyed with the title to 12 North Street. The parties stipulated to that below. So not only did they not advance a contrary argument, the parties agreed below, and the judge went forward sua sponte and declared a portion of 12 North Street that the parties agreed was owned, a portion of North Street that was owned by 12 North Street was declared to be in the title of the Walstons, and the parties agreed to the contrary. So there's no reason to remand on that point.
They agreed that it was owned in fee by the predecessors of 12 North.
Yes.
But what about, the judge said, well, this moots arguments about easements.
Oh, yeah. So there's no need for remand, Your Honor, because the evidence supports what the court concluded. The court also did conclude that there was no evidence of use beyond the area of B, beyond the area of C. So the court concluded that there was no evidence, I'm sorry.
So the same argument that
Yes,
goes
Your
for
Honor.
B goes for A?
Because it's further along North Street to the east. You've been exceedingly generous. Thank you.
And we'll make sure it's fair, so don't fret, anybody. Okay, now we'll hear from Attorney Goldsmith.
Yes, good afternoon, Your Honors. Michael Goldsmith for the Bunn parties. The Bunn parties own property at 1 North Street in the so-called eastern section. And the Bunns did not participate in the trial because, and while I'm at the appellant's table, I'm before you asking that the summary judgment decision be affirmed because the Bunns benefit from that the portion of North Street on which they reside is essentially a cul-de-sac blocked off from the remainder of North Street. And what I'd like to pick up on the questions that Justice Sachs had about the extinguishing argument. And I get it. The issue raised and really addressed by the appellees is that there was a requirement that Robert Carroll had to plant what the judge called the shrubs as a blockage in order to establish extinguishment. I think you have to look at the overall circumstances here, that in 1977, as Mr. Moriarty was saying, North Street was a wide open way. It was a way that you could pass through east to west from Peases Point Way. Robert Carroll owned the road. He owned on both sides. When he deeded out the Lot 1 to Teller. Then he goes to the planning board in 1978 to create this development that he did. And in addition to requiring him to do South Street, the planning board had him do 3 things about North Street. You got to clear out 2 more feet on each side, and this is the Form C, the approval at 3/225 in the record. This is what led to the case file 167. You got to clear out 2 sides. You got to put some bluestone on it, and you have to crown it up in the middle. So he was required to improve North Street so folks using North Street, the Tellers, any of the lots that he created, would have easy access to the west. What he didn't do was clear through any shrubs that existed there. we don't definitively know if Carol planted them.
So you're saying it doesn't matter whether he planted them, they were there?
Exactly. I think Teller testified that Carol blocked the road, but I think you can construe leaving the plantings there or planting some additional, or planting some himself, or a combination of the two. When you look at it in the context of him improving North Street to the west as an affirmative act, it doesn't make sense that planting is a talisman. I mean, if he'd gone out there...
It doesn't have to be planting. It could be a fence or other kinds of obstacles there or somewhere else along North Street. But if you're relying on an extinguishment theory, prescription, you basically acquired the easement back by prescription.
Yes.
There's got to be some affirmative act. And I'm not seeing how leaving natural vegetation in place is an affirmative act, if it was natural.
Yep.
So that's why the judge's acceptance of the Teller testimony on summary judgment, followed by his testimony, well, I don't really know because I never went out there to look, it seems difficult.
Well, Teller clearly says multiple times he blocked it off. And we know from the other evidence at summary judgment that it was blocked off.
Well, it was blocked off by something at some point, vegetation. We don't know exactly where. But if Teller says it was blocked off or he blocked it off, but at the same time in his summary judgment, in his deposition says, but I don't know because I never went out there, how can that establish as an undisputed fact that Carol blocked it off?
Well, I never went out there doesn't mean I couldn't see it. You know, he was the clerk magistrate of the court.
I don't really know because I never went out there. He's saying I don't have personal knowledge. Is there another way to construe that?
Well, another way to construe it is nobody else went through there except the 6-year-old boy, maybe cut through on a few occasions. Stephanie Teller, who acquired the lot in 1984, only a few years later, says you can't cut through. And
it was impassable for some reason, but unless it was due to Mr. Carroll's actions, then where does the prescription come from?
I say the prescriptions come from the overall act that Carroll did with respect to North Street. By improving on one side, as the planning board required to him, he had to have done that in order for those 1978 lots to be released, and not removing...
How far did he have to improve North Street?
That's unclear. He had to improve it up to, I would presume, as a reasonable inference, is to where it met South Street that he built out, so his new lot owners and Teller could get out.
Oh, he should have put a crown on North Street all the way to South Street, but he didn't. Maybe he stopped at where MS Way comes in from the north. How is that an affirmative act, that he's not doing what he's supposed to do per the planning board?
Well, I can see I'm not persuading Your Honor on that, but I think that if you have to look at all the facts, what he did to North Street and what he didn't do on some portions. That's what I'm saying. Can I address abandonment just for one moment? Because I think abandonment was also strong at summary judgment for the reasons that Mr. Moriarty argued, because the teller's act of going out South Street to Cleveland Town Road, another public way, is an affirmative act. It shows their intention. It's direct evidence is what they did.
It has to be an affirmative act that's inconsistent with the easement. And I'm not sure how using an alternate route is inconsistent with exercise of the easement.
Another document to look at, which I think is really important, is the instrument at 3241, and this was an easement that Thomas Teller, when he granted Lot 1, the Walston property, to his daughter, at the same time, he and his wife, Esty, gave Stephanie Bell and David Bell an easement to go over their property and to Mullen Way. And Mullen Way is parallel to North Street to the north.
So it's another way of getting out to Peace Point.
Another way out. So that's evidence of his intent that we're dropping our right to go through the bushes at the Carroll lot and out to Peases Point Way on North
But for
Street.
some reason, that easement was taken back at some point.
Well, once you sold the property to the Walstons, they decided to revoke it. But it shows, it's evidence of intent.
Okay.
And one more point, the Walstons asked for you to remand the case for yet another proceeding on abandonment in their brief. Now, I'm not stealing from the trial record, but the motion judge was the trial judge. He went ahead and found, after hearing himself, forget about depositions, he says, now I'm convinced, after hearing them at trial, that they abandoned their rights in North Street. What more could the judge, what could the judge do on remand? He's heard the witnesses, he's made his decision.
Well, she might say, we didn't know that was on the table, so we didn't work on trying that.
Well, you can look at the issues that were to be tried, and one of them was abandonment. It wasn't abandonment of the easement rights out to Peases Point Way, but it was abandonment of the rights in North Street, the remaining section. So abandonment was on the table, and the tellers testified before Judge Fay, and he reached those conclusions. And he also referenced the summary judgment decision throughout the trial decision. So I do see the lights blinking and over, and
Okay.
be respectful of everybody's time, but thank you, Your Honors.
All right, and now we'll give the Walstons time. We will put 15 minutes on the clock, but if you feel like you need more time, we will be fair, as I said.
Good afternoon. Danielle Long for the plaintiffs, Matthew and Jean Walston. We could probably argue this for days with all the facts and the summary judgment motion and the trial decision. So I'm going to try to break it down, and I think what I'm going to do is start with Area A, because I believe that is sort of the one true issue that is a matter of law right here that is not really factually dependent on the summary judgment record as well as the trial record. Looking at Area A, as my brother said, abandonment was absolutely at play in this lawsuit. So there was a counterclaim for abandonment by the McNeils that then they were substituted for the Bunns, and there was also an affirmative defense for abandonment in the litigation. And you cannot abandon a fee ownership in a way. And that was the reasoning for the judge's decision. It wasn't a sua sponte decision. All of North Street from my clients, basically from the fence on, all the way out east to Peace Point Way, was at play. If you look at the issues designated for trial, it's clearly in there. If you look at the relief in the complaint, we asked for a declaration that our rights, titles, and interests in all of that section of North A was superior to all others. So I really think, I know there is not an exact case on point with respect to the Area A, because what we have is sort of fees in intersecting ways. And yes, my clients did go and buy that fee in the middle of the lawsuit. I think we bought it between, I think by the time we had, I wasn't the first attorney on the case, but I think by the time that we had bought those fees. With respect to Area A, I think it's really important to point out the parties did not agree that the fee at the intersection between North Street and Middle Street was reserved by Mr. Teller. And I will direct you to, it's actually agreed upon statement of fact number 18, where the parties agree that the fee in North Street on the frontage of the Walston property, that fee was reserved by Mr. Teller. So Area A is at the intersection. So at the time, it's a very, to me, a very traditional analysis of the derelict fee statute, because at the time, Mr. Teller still owned, which was Lot 2, which was to the south of the Walston property, and it also, he owned the property that went on the other side, I guess to the east of Middle Street.
Let me stop you on Area A. Did the parties have a fair chance to argue over whether the derelict fee statute applied based on the Walston's acquisition of MS Way?
Yes, I do. Yes, we did have a fair opportunity.
Did you in fact argue derelict fee as to that acquisition of MS Way?
Well, at the trial, we didn't really argue derelict fee at all, because it was the admitted trial record and the agreed upon facts was all the title because that trial would have been 10 days if we didn't admit to the trial. So we basically took the summary judgment record with all the title, put it in, and put it in the agreement of facts. But it was a defense to abandonment. The trial court judge can't make a ruling. They're asserting abandonment, and his decision is there cannot be abandonment because they own the fee. You can't abandon a fee interest. And there was no adverse possession claim by the defendants for that area in the intersection. So it was absolutely in play. I mean, again, I argue this trial judge, no one argued prescription on summary judgment either. They argued abandonment. That was their claim for summary judgment, yet the judge said, no, you didn't have abandonment, you had a prescription. I guess the claim was at issue. The trial judge is free to apply whatever theory he wants to apply to make that decision.
You had no affirmative claim that you owned Area A?
No, we didn't think we needed one. We amended our complaint and asserted that we had the fee. And then I think it does become a question of law, the derelict fee statute.
Because you purchased it, or for another reason? Or
No,
both?
so we purchased it. So Teller had reserved the fee on the frontage, basically the frontage and sidage of the ways in his various conveyances. And then we went and purchased the fee from his daughters. His 4 daughters were still alive. And then at the time, we had done, I don't think I had an expert yet, and then we had retained our title experts and what have you. And then we realized that the fee, in fact, did pass with, Teller did reserve the fee along the frontage of our property, so we weren't going to pursue that. We knew that that was correct. But there are the deed from, we call them the Carroll sisters, to my clients is for the fee in Middle Street. But I do think it's a very simple application of the derelict fee, because I don't know what's the other conclusion, that the Teller owns the entire fee in the width of that intersection, because I think it's very interesting to note, and you can actually find this analysis in their own expert report in the summary judgment record, from the Walston property boundary on, they only have own the fee to the center line, because nothing was reserved. The only, in the record and in all the deeds, the only fee that was reserved by Teller in the full width of North Street was on the land that fronted our property.
Teller or Carroll?
Carroll, sorry, yes, Mr. Robert Carroll. When he sold to Teller, he reserved only the fee in the frontage. And it's an agreed upon fact. If you look at the language of the deed from Carroll to Teller, it says we're reserving the fee in the area bounded by this property. So I think...
So the area, the part of North Street that is immediately south of the, maybe we should look at the, no, you know, I'm not going to go there.
Now, I'd like to, if there's no more questions on that, I'd like to move to Area C, the adverse possession claims. I think the record is very clear, I believe, how the trial court judge determined Area C, B, and A.
But for Area C, it's just east of the fence.
No, Area C, actually, if you're looking, it's very faint. If you're looking at Exhibit A to the trial decision, the fence is actually this really thin dotted line that's maybe a fingernail to the left of the Essen Street. So the left-hand boundary or the western boundary of Area B is well after where the fence exists today. But, you know, Stephanie Teller and Mr. Teller, they were my main witnesses. They had to be my main witnesses. They were very hostile. But I think even if we eventually got out of them the testimony of the use of Area A, but I keep going back to there's so many aerial photos, and the photos just don't lie. And what I'd like to point your attention to specifically, I don't know if you have it in front of you, that RV, if you look at all the aerials, was not always parked in the exact same location. And in fact, my clients, when they looked at the property, they said it was even parked almost into the intersection under the tree canopy at the intersection of Middle Street and North Street, and they actually had to make it a term of the sale for them to move that RV.
Well, they would have made them remove it wherever it was. I looked at the photos, and I thought the placement of it was pretty consistent. But
Well-
where do you say that the back end of the RV would fall, looking at Exhibit A to the judgment?
So if you go to, it is Trial Exhibit 36, and it's in Appendix 4 at page 132. It's an aerial dated May 20th, 2010. And in addition to my, Mr. Walston testifying as sort of how the photographs and the RVs lined up with his neighbor behind him, so if you
I'm not
look.
seeing that.
I think you've got the wrong volume.
Are you looking at Record Appendix 6? What's the trial exhibit number?
Oh, is it 7? It's where, yeah, it's 6, I'm sorry.
Yes,
We have what exhibit with all the trial exhibits in it?
Okay, so 132, did you say it's Exhibit 36?
It says Trial Exhibit 36, and it should say May 20th, 2010
It does.
on top of it. So if you look at this picture as a whole, you can sort of see how, if you go way to the bottom, what is North Street, and if you follow it straight up, and if you go up and you see there's like the RV and the boat to the left, and if you keep going up, that's the Bunn's house to the right, and the Bunn's house directly abuts the paper Middle Street. And then if you go to the left, there's a neighbor's house behind it that abuts Middle Street on the other side. So what I think what it appears the judge did based upon these photographs, if you look at this particular photograph, the boat and the RV are lined up with the right side of that house, which is very close, about the same distance, that edge of the house, to the Middle Street right-of-way. So if you look at all these pictures,
It's up on whatever the street is to the north, parallel to North Street.
that's Mullins Way.
Oh, okay.
Yes.
That's
So-
the house you're looking at with the two dormers?
Yes, it would be, it's literally that house right behind the boat, like if you look straight up.
Behind the boat?
left
I mean,
of the
to the
boat?
left of the, or to the starboard of the boat, if we're,
Well, if I'm looking at this, here's the boat, it's behind the boat.
okay, yeah, all right.
And if you,
We've got it reproduced in portrait, but I see what you're saying.
yes. So if you hold the photo true north, that's what I'm doing, if you go up north from the boat. So if you look at that, where that RV is parked there and where that boat is, that is very consistent with the distance of where that house is from Middle Street. And then if you turn back, if you go up a couple pages to page 134 of that same appendix, and it is Trial Exhibit 38. That's June 15th, 2014, and that's maybe 2 weeks before my clients bought the property from Stephanie Teller.
Could you just hold that up so I could see which way you were holding it? So you want the exhibit sticker in the lower right-hand side?
Yes, that's from trial. And if you put the date up top, that's true north.
Got it. Keep going.
And if you look in that picture, the RV's gone by that time because we were about to purchase the property, and there you can see like a little red car in there. And you can see the opening before the tree canopy starts, again, sort of consistent with lining up with that easterly side of the house to the north.
Easterly or?
Yes.
Oh, okay, yeah.
Or to the right. I mean,
okay.
again,
Yeah,
it's aligned truly with the north-south. So I think there's just numerous photographs, and Stephanie did eventually at trial admit that, that it was her husband's RV, it was her husband's boat, that the husband bought the boat in 1988, and he bought it when the child was an infant. I'm sorry, the son was born in 1988, bought the boat a few years later. She testified her husband, would take it to Florida all the time. Yeah, I outlined in my brief about 8 different photographs, all different times of the year, summer, spring, winter, where that RV was shown.
Just so we are clear where we are, you were getting to explaining how the judge placed the line between where they parked the RV, putting aside how frequently for the time being, and where their parking use stopped. So where do you say that is on any of these photos that you're pointing at?
I say it's about, if you looked straight down, it's about where that boat, see how there's an RV and there's a clearing behind it where they maneuvered in the boat? That is about approximately where the eastern boundary of Area A is, and it's well past where the existing fence is today, because that existing fence today is that dotted line on the plan that's Exhibit A.
How do we make a concordance between the Judgment Exhibit A and, the Judgment Exhibit A and any of these photographs to know where the judge put the line between the areas B and C that he created?
I think if you go back in the trial testimony, there is specific measurements from my client, Matthew Walston, measuring from the fence, and then also testimony sort of aligning when he purchased the property, how the RV was aligned with that neighbor's house in the back. And I think that is how the judge, and that is, I mean, is it inches perfect? No, but that is very consistent with how he delineated Area C and Area B. Because the issue was, the fence is, I want to say almost the full length of the RV to the left right now, as it stands today. And
West, in other words.
To the west, yep. And I just also want to make some notes about her use. Stephanie testified that area of North Street that's at issue in this litigation that ran along her southern boundary, she used it the same way since she bought it in 1984 to the present. Nothing ever grew on it. There is an enormous amount of testimony that if you didn't maintain that vegetation in this area, it grew like weeds. From bird droppings, her entire backyard, where she didn't trim it, was all vegetation. But she testified it always stayed open, and she always used it the exact same way from the time she purchased it in 1984 until she sold to my clients, the Walstons, in 2014. I know I'm getting short on time. I just wanted to quickly.
But we went over, so.
Yeah. I'll just quickly, I want to address, because we have two different issues with the abandonment. We have Area B from the trial, and it is our position, I know you have to defer to the judge with respect to the findings on adverse possession and what have you, but the trial judge went one step further in Area B and found that not only did we not establish adverse possession over Area B, we actually abandoned our rights in Area B. And we contend, first, again, going back to the very black letter law on abandonment, it was non-use. Okay, maybe there was some vegetation that was allowed to naturally grow, but again, consistent with deposition testimony and trial testimony, Mr. Teller never went out there. He actually was consistent at trial with his testimony as he was in the deposition. He never had any reason to go out there. Stephanie never installed anything, never put up a fence. No one saw an obstruction. All the case law that is supported by that is cited by my brothers include non-use plus a fence, plus stones, plus a stockade. We do not have any of that here.
A lawn? Plus a lawn?
Plus a lawn, but I cited case law. Use of a lawn by the dominant estate owner will not amount to an abandonment.
But that was enough in Carlson v. Fontanella to kind of push things
It was,
over
but
the
then
edge.
I would direct your attention, Your Honor, to the case that distinguished that, Florian v. Cooper, that came 7 years later in 2016. That specifically addresses the use of an easement as a lawn does not amount to abandonment.
Okay, but use of an easement as a lawn and planting a lawn and putting sprinklers in the lawn. I mean, certainly putting a irrigation system seems inconsistent with using the area for vehicular passage, at least.
Well, so the sprinklers were well under the ground, and there was frequent parking and use by my client on that area.
In the area where the sprinklers are?
Mm-hmm. Yep. And there's testimony in the trial record of that. And also, too, we have vehicular passage, but you also have pedestrian passage. There's numerous testimony from my client, using that North Street, particular Area B, to walk through the intersection to town. But what I want to point out with Area B is the trial judge relied on the fact that the teller and Stephanie thought they gave it up. They agreed to give it up. But all that testimony, thinking we gave it up, agreeing to give it up, which in our position, that is not enough. But that all had to do with giving up their rights in the eastern section. And we really differentiated in our brief the testimony on that because Teller said he thought he gave up the rights to travel to Peace Point Way past his property, past the intersection. Not Area B is in the middle of our lawn. And with respect to Stephanie, she testified that she agreed to give up her rights to walk on North Street past the old railroad right away. Again, this testimony is all cited in our brief. And then she said the old railroad right of way is the intersection between Middle Street and North Street. I don't know how the judge came up with relying on the fact, one, that Carol installed shrubs anywhere in Area B or anywhere to block off eastern section, but that he also relied on testimony that Teller thought and agreed to give up his rights, but there is absolutely no testimony that he agreed to give up his rights in Area B, that where the boundary, the eastern or the western boundary lines up with a good chunk of our backyard. And with respect to quickly to the eastern section, as I said before, the original argument on summary judgment was abandonment, and then the decision came back prescription. But I would argue there's neither. Again, you have just the actual use with no natural vegetation growth. There's no evidence whatsoever that Carol went to the nursery and bought plants and seeds and planted it in that area. But also, based upon the judge's finding of prescription, you need actual use by the servient estate. There was no evidence of actual use.
What's beyond the obstruction, or isn't placement of the obstruction itself enough use to create an easement or extinguish one by prescription of what's beyond it?
If there was an actual affirmative act of building and maintaining an obstruction, but you don't even get there because there's no obstruction, because I think there is ample case law to support that non-use in allowing natural vegetation to grow is not enough, and failing to maintain is not going to equal.
Mr. Carroll had built a fence along the eastern edge of the extension of the MS Way through the intersection. If he'd built a fence there instead of shrubs, which he may or may not have built, wouldn't that be enough to extinguish by prescription your client's
if there was a fence actually built by Carol?
Yes.
Yeah, I would agree. We'd have a much harder case.
Everything
100%.
to the east of that.
Yeah, because that's an affirmative act.
You have to use the eastern section itself as long as they block off access to it. Okay.
Because, I mean, we could still walk through. Stephanie's son even walked through. I think it really just goes back to the fact that just letting vegetation grow here, and twice in the summary judgment record and the trial record, he relied on this theory that Mr. Teller planted bushes and nobody ever went out there, with all the evidence surrounding it is if you didn't cut your trees in this area, they're going to grow. And just quickly on substitution, we contend, as we briefed, he may have tried and wanted to substitute the easement, Mr. Carroll. He just never legally did it. He should have. South Street, if you look at the dates, South Street didn't come into existence until 1 year after Carroll sold the property to Teller. And then when Mr. Carroll developed South Street and those lots below, and when he sold those lots, he paid particular attention to reserve an easement in South Street for himself and his heirs.
And his assigns.
And his assigns.
Could his assigns have been the owners of Lot 1?
No. Because he would need to specifically reserve an easement for the Walston property to access in a public way through South Street, which he did not do.
I guess I'm asking what assigns means. What does assigns mean in that context? Does it give him the right to?
He could sell it.
Only sell what he has, but couldn't he go to the owners of 19, is it? I'm getting mixed up with all the
Yes,
numbers.
19's our property.
Okay.
He could have, but he didn't.
Owners of 19 say, I'm assigning you part of my easement in South Street.
He could have, but he didn't, and that's what's so telling.
Right, but did he reserve the power to do that, I guess? I mean, the judge drew a...
He could have. I would have to, again, I think I would have to examine that more further, but he didn't do it. The fact is, he had the power and the ability and the standing to convey that easement. And you can substitute relocate, like use whatever verb you want, but he still had to put the owners of South Street on notice, with record title, right, on notice that the property above them had an easement to travel past their homes to a public way, and he never did that.
I want to make sure you feel fairly treated because we did let them go over a little bit more than this.
Yeah, no, I think I went 8 minutes over, so
Okay.
unless you have any further questions for me, I'll rest on my brief.
The case is submitted. I think, well, I'm not going to say we understand your arguments, but we aired them, and we'll decide the case. I really want to extend a great thanks to our staff because this has been a longer sitting than normal, so I always say thank you, but an extra thank you. So with that, the panel is in recess.